Good morning, ladies and gents, and very, very welcome to today's session. You'll notice it is being set up until 2 o'clock this afternoon, so it is a very long 5 hours that we got ahead of us. Also a lot of information that we have to cover. So let us just talk a little bit about how we're going to flow this morning session so that we all have a little bit of a breather every now and again, and that we always stay constantly alert. So we're going to run until about 10:15. I'm going to give you a little bit of a break. Our first couple of breaks, I tend to give you 10 to 15 minutes. And then as we go along, I'll keep a tab on how much more information we've got to cover, and the breaks might just be a little bit shorter. So the first one will be at 10:15, then at about 11:30, 12:45, and then 2 o'clock, and then you can go and have lunch or drinks, whatever it is you're going to feel like after today's session. As I go along, I haven't introduced myself. I do apologize, but I'm sure you all know that I am Carmen. How we're going to do this as well is all the questions that you have, I would like you to please text in that little box. I hope you all know how to use the webinar, but at the bottom, I think on the right-hand side, you've got a little text box. Please do text me your questions as we go along. I think you'll appreciate that there might be a lot of questions because we've got about 85 attendees on today's webinar, so I might not be able to address all the questions as we go along, but during our break, I will have a list of those questions, and where I feel some of those questions either are a trend or very applicable to this exam on the 16th of February, I will answer it during the answered, and FPI will either distribute it to you or have it on their website. Any other concerns, etc., that I haven't covered, by all means you are free to give me some feedback. So let us start today's session, and I think what you see in front of you, I hope you can all see my screen, but what you see in front of you is a little sample question that FPI has on their website. I can't actually recall which year this is, and that's why I've got it up there. The reason why I have it up there is because I got a very interesting question yesterday where I was asked, how would I address this particular exam? And the reason why I'm starting this is because I don't know how many of you actually attended the face-to-face workshops where Lalana was explaining to you how to prep and what to expect of the exam and what to do and what not to do. So I thought I'll spend a couple of minutes on this particular question because it is actually very, very interesting. So my approach to any form of exam paper, strangely enough, and I might shock some of you, and that is the first thing I do is I actually go straight down to that question. Because you must remember, just look at the amount of pages of information you've got in front of you. There's many, many pages. And I can sit and read everything. I'm not going to be absorbing everything as I read. So normally what I do is I have a little mind map next to me in terms of information that I feel is relevant. But while I'm going through it, your mind can kind of ask, well, what is actually relevant? I mean, do I take into account they've got 20 dependents? Do I take into account they've got a trust? I don't know. So my first thing is, what is it that I am supposed to answer? What is the question? So I go straight to the question, and I'm not going to read everything, but clearly what they're trying to do here is they're saying he's got concerns regarding his retirement situation. I go further to read, and it says, based on all the information, prepare a short report, maximum 3 pages, and it goes on again to say only 3 pages will be marked. So if you go 4th, 5th, 6th page, they're not going to look at that. So limit your answer to 3 pages. That's where your 25 marks is going to sit. How am I going to do this? First, it goes on further to say no calculations are required. So don't start doing a retirement plan calculation. Don't do estate plan calculations, particularly telling you don't do any calculations. Now, depending on where your strengths are, some of us are very good at calculations and we motivate something around particular calculations, and some of us happy to do theory. So you've got to understand where your skills are, and hopefully some of you have gone through this paper and thought, well, if they've asked for no calculations and that's my strength, how else am I going to be addressing this particular question? I love this question because I'm not very good with calculations, and I'm so happy there's only 3 pages that I have to complete. That means I don't have to do like a 20-page report, which we generally do for our clients. So now I know what I'm after. He's concerned about his retirement. I have to concentrate on theory rather than calculations. So now I'll go back. I'm just trying to remember how to maneuver this whole setup again, so please just bear with me in terms of pages going up and down. So now what I'm going to do is I'm going to read the case study, and I want to pull out everything that I'm going to need to try and understand why my client is concerned about retirement. What has happened in his life recently that he has those concerns? And automatically, the fact that the client has a concern already tells me the chances are there's a shortfall. I won't be concerned about something if I'm feeling comfortable about it. So maybe that's why no calculations needs to take place. So I start off by picking up that my client is divorced, and he's only recently got divorced. So we know what divorce does from any time of planning, death planning, retirement planning, succession planning, doesn't matter what it is. Divorce is a major impact. So now I know he's divorced. I also have obviously his age, because that becomes important. How many years does he have to plan for retirement? Because this is all we're concentrating on, is his concerns about retirement. Well, this is a big factor. 50% of his pension interest is gone. Okay, so now relate this to yourself. I've worked hard. I have had 100% of my pension for retirement planning. Now, all of a sudden, at this age, 50% of that wealth has just gone. Now I've got to catch up, because I'm only now left to 680, because 50% went to his wife. So now I've got to all of a sudden catch up. 680 Rand, that's just capital that I've lost. What about the growth on that capital that I would have got if there was no award that had taken place? So this is major, that half of my wealth for retirement is gone. So of course that's a concern. So first thing you're going to do in your mind is, okay, if he's got, I'm just going to assume here, if he's got 10 years to go for retirement, how am I going to help this individual over a 10-year period to actually make up the 680,000? I've got to start thinking like it. So let's go further with the case study and see where can we pull this out. So Alexa was awarded the family home where her and her children will continue to live. Okay, so who's our client, by the way? Sam. So Sam now is totally on his own. He doesn't have those dependents there, but maybe he has to maintain them. So let's read further. He now had to buy and move into a townhouse. So now listen here, I've lost half my wealth. I've had to buy a new place to move in. That means that I have extra liability, which I perhaps did not plan to have at this stage in my life. So I'm having to pay a bond. I've increased my expenses, which was not expected. Lost half of my wealth, increased my expenses. So now, does he actually have surplus income to play with? I don't know. I'm going to have to read further to see. And he's got the household goods. Well, brilliant. There's nothing really we can do with the household goods. I'm not going to tell him to sell his bed and his fridges and things like that. So that's definitely not going to help us. Okay, so a good thing is that he's actually kept all the investments that he had. That's brilliant. So now I'm going to have to take a look at what is in those investments. Did he allocate it for anything in particular? Perhaps he's kind of gone, you know what, these investments that I have here is going to help me to pay school fees, is going to help me to pay, maybe I'm going to use it towards my bonds. So I've got to try and understand in his mind frame, if I can't work it out, if the case study doesn't tell me what he wants to do with his investments, well, that's part of your recommendation. Maybe those investments should now go towards retirement. Or maybe those investments can go somewhere else. How are those investments growing? If it doesn't tell us, you're going to have to play around with that information that's given to you. Sam is responsible for school fees and medical expenses until the age 18, as well as having to pay maintenance for each child until they're 18. I've got a feeling that this has increased his budget again. While the children are with me, maybe I'm not having to pay maintenance because I'm already paying school fees. I think jointly we are paying for clothing, for entertainment, etc. So now it nearly sounds like as if I've got this additional responsibility. Again, what has it done for my surplus income if I have any at all? Well, luckily he doesn't have to pay for his wife, so we're comfortable with that. It goes further to say that the divorce was not amicable. I don't care that it was not amicable, but the thing is it's very traumatic for Sam, so you've got to understand the emotional situation is in. He's probably not thinking clearly. Clearly he's has no hands on his financial situation, so I'm going to have to take that into account. He's asked for his employer to be seconded to Brazil. Okay, so he wants to go and work in Brazil. So maybe that is a good thing, not a good thing, we don't know. But remember, if I am working outside, if my services are rendered outside of the country, and I still have a pension fund here, I've got to establish whether the pension fund here, if contributions are still being contributed to that fund. Because remember, from a tax perspective, you've got that lovely little exemption. Of course, you're going to have to understand all the requirements. How many days must I be out of the country? And look at those 10 days coming back. That's not a recommendation. Stay out of the country for more than 165 days. Don't return for a while. Because then what happens is the services rendered outside of the country, the income that you receive are generally not taxed in South Africa. There are double taxation agreements, but you're not going to see DTAs here, so you're going to go with this information and say, hold on a sec, now I'm earning all this additional income, the chances are it's not going to be taxed in South Africa. I know because the information is a little later, says it's also not being taxed in Brazil, so I'm probably earning this income and it's not getting taxed at all. So this is additional income that I've got to work on. Maybe I can take a huge amount of that income and allocate it towards retirement. So you start thinking like it. Can you understand that all the knowledge that you have obtained in your post-grad, all that must come to you now. So every single sentence you read, try and understand what that means to you in terms of all the knowledge that you've applied. This one here is a big one to remember. I've got a lot of income now that the chances are it's not taxed. I can use a lot of that income going towards retirement. And it also says detail in Annexure A. So you can either go directly to Annexure A and say, what does it mean? Or you make a little note on the side. I would just make a little note on the side saying, make reference to Annexure A, because that is definitely giving information here. Too much in this paragraph for you to ignore. So it goes on in terms of goals and concerns. He's very depressed. That's fine. I'm sorry for him. And of course, the divorce has had an impact on his financial affairs. You've already seen it from that perspective. And his motivation when asking to work abroad was to get away from his immediate environment, to clear his head and think his future. That is brilliant as well. I could read a lot of things into that, but I'm particularly looking at information reliant in terms of retirement planning. So I don't know if that is very important information at this stage. Maybe I'm missing something, I don't know. He feels that he has lost his financial security. I can understand that he's built up over the years, and he has no idea how he'll be able to recover from this. This is what you have to do. This is his concern. That's the question. The question says he's concerned about retirement planning. This is now your responsibility. This is your job as a financial planner to kind of go, okay, Sam, don't worry about it. This is the picture I can paint for you. You do not have to have calculations here whatsoever. And of course, don't forget, besides his story, now he has an aging mother on top of his priorities. This poor man, no wonder he's disappearing. Unfortunately, he still has to stay on earth, because the only way he's going to disappear is if he decides to go to heaven, which he's not going to do. He does not know how to structure his investments. Your duty. The family home was awarded to Alexa. He had to purchase his own townhouse, repetition. The bond is now an additional liability. This is what we spoke about. Okay, so his expenses have increased. He is concerned about retirement. He has hoped to retire at age 55. So now you know how many years he's got until age 55. And you can even, of course, you can even consider or recommend that he delays his retirement by another 5 years. But that nearly sounds like a very general answer. I mean, you can't just tell your client, oh, sorry, let's retire a little later. What you've got to first do is try and get all the information your client's given you, try and develop a plan for this client, and then only if that plan seems like it's going to fail because it truly doesn't have any other way of making up his losses for retirement plan, then you can go, you know, let's retire another 5 years' time. But try and pull out information that has been given to you before you just opt for a very generalized recommendation. Okay, so it says your calculations indicate that Sam's monthly cash flow can cover his children's maintenance. Don't stress there. I don't have to worry about putting anything away for the children. So the investments that I have does not have to go to the children whatsoever. He also feels that there is sufficient liquidity in his estate to meet when he's passed away. Again, all my recommendations are going to be towards retirement planning because he doesn't have any other concern. He doesn't have shortfalls in terms of any other aspect of his financial situation that we would normally be addressing. Then, of course, it gives you a whole lot of information, a child, his dependents, how much he pays, all these things you've got to take into account, what his what he does, how much he earns. He earns quite a bit of money. So take a look at some of the investments he's in. Is it the right investment? Is it not the right investment? The fact that he's still going to be paid. Look at this bonus, Evans. I didn't even pick up that bonus, and he's got a bonus. What is he doing with this bonus? Retirement planning. That's perhaps where it can go. And it talks about, see comments on this year and next year. We'll be working in Brazil, and this is the amount of money he's going to be getting. And somewhere down the line also mentions in the next year that he doesn't get taxed in Brazil. So now I want you to think of something. So let's just go a bit further. There's a pension fund. When he joined, it's a defined contribution. Of course, so then in that case, it is a percentage of his salary. Consider increasing that percentage if he can afford it, which I think definitely he can. And here I've got my current value. And here I've got my asset allocation. Remember, Reg 28 is very important if you are going to decide to increase equities. There's those limitations that you've got to consider. So here again, some more information for you to play with. I'm just running through in general what you need to look at. I'm not going into major detail. I just want to try and pick up on a couple of things. The employer is contributing, sounds like 7.5% as well, because some of that 9% goes towards risk. That's not going to help us. He's also contributing. Now, perhaps the 7.5% can increase. Why not? But let's look further. He's got life cover, which we're not too concerned about, because remember, he says he's got more than sufficient, and he's got disability income, also to me sufficient. Of course, what we can question there, but I'm looking at retirement planning, is if that will still pay out. Then it goes general comments. 680,000 individual reserve in the pension fund was paid to the wife. We understand that. Important, group benefits remain intact while working overseas, but no contribution will be made to the pension fund during this period. Now, perhaps this is a big factor to look at. Why not? Because this is ideally what you want. You want contributions to continue being paid into that fund. Because why? Because at this stage, I know there's a slight income tax change, but it's only coming in the 1st of March 2017. But this paper was long before anyway. So why not contribute? Because you have that exemption for services rendered outside of the country when that pension fund pays out. Can you see the more lump sum I can take out that is not being taxed, of course that is going to enhance my retirement planning. So this would be a big factor, and that would be a major recommendation. Is so if the employer doesn't want to contribute, that's fine. Why is he not contributing to the fund? That would be important. If he cannot, if there are rules to the fund that says he cannot, then perhaps a recommendation to look at is with this additional income, or rather this additional contribution that he's not putting away, there's a retirement annuity opportunity. Okay, and don't forget, premiums disallowed. Eventually, when I do retire, those premiums disallowed are going to be a deduction against my lump sum. So again, I'm increasing lump sum tax-free, which is something that is needed at the time of retirement. And goes that says global in technology, the affiliate, the international affiliate does not deduct any income tax from the income tax earned offshore. Now, ladies and gents, you don't have a double taxation agreement. They're not listening to see you have tax consultants. They're giving this information to you, for you to see that I've got this $8,000 or whatever it is that I'm earning overseas with your rand exchange. Heavens, I've got potentially a lot of money that I can now play with, and that can go towards retirement planning to make it up. He's got a medical aid. Now, I would probably be questioning this medical aid. Yes, I know he's got Liam and Nisa. They are dependents, but can they not go perhaps onto the mother's medical aid and you contribute? Why are you on a medical aid while you're in Brazil? That might be a need. I don't know. I'm just looking at that and I would be questioning it, because if I can save a little bit of monthly premium, I probably would do that, because it's retirement planning that is a concern. So I'd definitely probably put Liam and Nisa on the mother's medical aid. I'm still responsible for those contributions in any event, but I might save a little bit. Now look at here. This is something I would sort of look at, is while I'm in Brazil, I'm having to pay this bond, am I not? Because I still have a liability, there's bond, water and light, you're going to see part of the expenses. So why am I perhaps not renting out this townhouse while I'm in Brazil? There's nothing wrong with that. 1-year contract, 6-month contract. Because if I do that, doesn't necessarily mean it's going to give me additional income. Not at this stage, but it definitely could help me cover the expenses in running this townhouse while I'm overseas. Why am I paying for something that I'm not utilizing? So if at least the bond, water and lights, etc. are covered by a tenant, can you understand that I've got that additional income, or that an extra bit of surplus that I don't have to sit and worry about? There it goes, retirement planning. And not everything into an RA either. I can do many other investments. There are tax-free savings accounts. There's endowments, although endowments I'd question. There's a lot of things I can do. Of course, RAs do, retirement funds do help from a tax perspective at the time of that event. I've got a car. Do I need that car? The fact that I'm still paying off that car, do I perhaps need that car? And I've got a motorcycle, but there's no liability. So I would kind of go, I would probably sell car. I would probably sell car, save myself a little bit of income. When I come back from overseas, I got a motorcycle. And I would be in a different position financially, relook, reassess, and then perhaps buy another car. That's just a thought pattern. I would be looking at, obviously, probably retail bonds. Why am I in retail bonds? I don't know. Question, why am I in retail bonds? I think perhaps a little bit too conservative. I don't have a problem with his local unit trust. He does have a retirement annuity, and then it talks about investment as per Annexure B. Of course, I'm going to be looking at that annexure. Take a look at asset allocation. Consider, again, it's Reg 28 that I've got to consider. Take a look at, he's got an existing RA, perhaps increase that contribution if I'm not contributing to a retirement fund. I've got an endowment. You've got to understand how the taxation of that endowment works in terms of a five-fund approach. So a lot of this is also touching on the exam that you're going to be facing on the 16th of February. Nothing here is really not something that you shouldn't know. So we're really starting to touch on a little bit, okay? So I'm not uncomfortable that I'm taking up a little bit of your time. I've got that life policy, and I don't know if I'd be taking away this life policy, because remember, he has said that he's very comfortable with the state duty, so I don't want to go play around with that. So I would leave that totally on its own. What other information? Well, look at there. There's the thing there. That bond, I can save the bond. I can save the car. Of course, I won't have groceries now, but I'll have groceries then. I won't have cell phone now, and I'll have cell phone then. But I might be able to save domestic help because I'm leaving. I'm going overseas. Do I need or don't I need? Maybe medical scheme, I can just lower it slightly if I make those adjustments that I've mentioned. I will not have rates and electricity problems because I am renting out the property. Yes, I will still have entertainment. Yes, the chances are I will still have petrol. Maybe this DSTV can be done away with for a little while. If not, maybe the tenants are going to pay that. I'd have to obviously question what that short term is, if it's for the bond, of course, off it goes, and now with maintenance. So by just looking at some of the information that's already been given to me, the way my mind works analytically, for myself, so I would apply that sort of principle for a client that has retirement problems. Can you see that without any calculations? I've been told the clients have concerns. Why must I do now a retirement annuity, retirement plan calculation? And based on what figures? No figures have been given to me really that will help me with a retirement calculation. I don't have to do any calculations if I think about it. And I think all the information that I've just pulled out, if I put that together and make recommendations, I'll cover 3 pages. I don't have to go further than that, and hopefully I will attract at least 20 of those 25 marks. So the young gentleman that did ask me this question, yes sir, I hope, and you can text me to say whether you're happy with the generalization or the type of things that you can utilize to answer this question. I hope that that has definitely helped you. If not, and if anyone else has any other question based on this, how do you approach any other form of case study, by all means, you're welcome to send it through to me, but that I particularly will not answer in today's webinar. That I will come back to you via FPR. So, ladies and gents, that's how you sort of touch on an exam. That's how you prepare yourselves. Take all your knowledge, and this is what it's all about. If the board exam, the PCE, is not necessarily about testing specific parts of your knowledge. What we are trying to do in these exams is we're saying you already have the knowledge. I don't want to do it in detail, but apply your knowledge to a particular case. And I saw there in terms of the facts that were given to you, that they were actually drawing on your knowledge and kind of going, do you understand what this implication has and what that implication is? That's the fact that they were in Brazil, the fact that they gave you 10 days coming back, all that was actually testing your knowledge, but how do you apply that back to your client? And that's important, and that's the way we're going to go forward. The webinar, of course, I'm going to have to refresh you on some of the knowledge that you do have, so that just in case there's something I may touch on that you didn't know about, so that's sort of the objective. But of course I've got a case study, and as and when I go through some of this facts and this refresher, I want you to try and tie it back to your case study. I won't always be able to have the time to go, what does this mean in Bella's life, because I'm going to obviously touch on some knowledge, but I want you to think like that. I want you to understand that our client is Bella, and that is our sort of objective. Of course, she may have dependents, etc., and those become our clients as well, but we're going to have to tell Bella how to deal with that particular situation. I want us to consider that Bella this year is 53 years old, and we're going to kind of go, well, when does she want to retire? Maybe she tells us. This is something else you must remember. I might not give you every single bit of fact in the case study, so you're going to have to work around that. Don't let that become a stumbling block. So Bella's 53 years old. More often than not, most people want to retire at the age of 55. So she's got 2 years to go. That might be totally impossible as and when you read the facts that she's given to you. And maybe in this case you'll go, no, young Bella, you've got to at least retire at the age of 65. Let us give ourselves a 10-year gap so that we can build up, be it retirement, be it whatever the case. Of course, I can't kind of go, don't die now, die only in 10 years' time. So that obviously won't work. But if I'm planning for retirement, maybe a 10-year period, but let's see what she actually has to say. She actually is telling you that her marital status in the process, she's in the process of divorce, but it's not yet finalized. So now this is where we're going to take a break. And we're going to go to your notes, and I'm going to guide you. I know your notes are going to be a little different to what I have. So you're going to go to from page 8, we're covering from page 8 to page 12, because what I need to do is refresh you a little bit in terms of marital status. Notice that what she has not told you is how she's married. So let us start with that. So bear with me again. I just want to go to page 1, or rather page, I said to you page 5, hey. So I want to go to this page. I want to go to that page. So again, when it comes to marital regimes, my mind does not really care about how you're married. I don't want to know whether you're married Civil Union Act or Marriage Act, or if you've got Customary Marriage Act, or whether you've got Matrimonial Property Act. My mind doesn't go there automatically. My mind just goes, are you married in community of property or out of community of property? Then if you're out of community of property, do you have the accrual, or is it without the accrual? So now Bella has just said, I'm in a process of divorce not yet finalized. And nowhere in the case study, if you've read it, is any indication of what her regime is actually about. So let's just go back. If someone says to you, or if your facts just say, I'm married, full stop, then you know that irrespective of what the act I've married under, I'm automatically married in community of property, full stop. If I don't want to be married in community of property, I've got to explicitly state I want to be married out of community of property, and if I say stop, then I am married with the accrual. But if I don't want the accrual, I have to specifically go further and say I want to be married without the accrual. So Bella, in my mind, Bella automatically is married in community of property, and she's in the process of divorce. So your mind must say, if I'm in community of property, how does this affect my client? And considering that she is divorcing but not yet finalized, that means if there's any particular event that takes place now, for instance, if she dies now, is she married? Is she not married? She is married because it's not yet finalized. So in community of property becomes a, be careful, half of her assets are going to disappear if she dies now, or if anything else happens now that is relevant, and she's not yet divorced. Important. So let's just go a little further and say, well, what if I wasn't? This is a refresher, so every now and again I'm going to go a little bit away from the case study, so understand how I'm running the session. So now we've looked at our marriages, and we'll go, well, what about unions that are not married under our Marriage Act? We do have generally two types of unions. We've got our long-term relationships and tenants of religion. Now, understand that tenants of religion, unless you are registered in within our laws in this country, so unless you're registered under the Marriage Act, you are really basically being treated as a long-term relationship, because that's how we see you. Why? Because whether you're a long-term relationship or tenants of religion, you are deemed, it's not that we have a marital system, but you are deemed to be married out of community property, i.e. what is yours, what is mine is mine. So that is sort of the marital regimes and the unions to look at. But remember what your guidelines state. Your guidelines says you need to understand your marital acts. If you hear a little bit of noise in the background, it's just because I'm trying to go through all this paper and pull out your guidelines as well. But if you look at that special consideration in terms of your guidelines, you'll notice that it does say right at the bottom, understand matrimonial regimes and how it impacts on various aspects of financial planning, estate planning, tax planning, and retirement planning. So I think what then becomes important is that you understand these particular marriages and these particular unions, how does it affect certain legislation? So let's go through to some of that legislation. So I think that's important. And you're going to have to just sort of apply your mind back to Bella, and also at the same time how it affects certain aspects of financial planning. So our first point is our Pension Fund Act. Now our Pension Fund Act really has two sort of events that we can consider. Considering that Bella is divorcing, I think it becomes important to understand the impact that has. So there's divorce and there's death. So what happens in terms of divorce? You know, divorce, Section 37D of the Pension Fund Act specifically just says what can be deducted. So maybe what we should have here is Pension Fund Act stroke Divorce Act, because it is the Divorce Act that really governs who can claim against the pension fund to have a Section 37D deduction. And you'll notice Section 7 of the Divorce Act specifically goes and says that if you've entered into a marriage that is excluding the accrual system, you cannot claim against that pension fund. So that is the only marriage that says you cannot touch. So if I'm married in community property, or if I have the accrual system, then of course I can touch or claim my pension fund. So this is what Bella is going to be facing. The Divorce Act says your married income mutual property, your ex-spouse, let's call it ex-spouse now, can claim against the pension interest. Doesn't mean they're going to claim. Just remember, when there's a divorce action, if you have money to pay whatever the decree actually says, then you pay. It's really to the point where if you don't have the money to pay your ex-spouse, they do have the right to then come and claim against the pension interest. So, very interesting. There is, I'm trying to figure out what the, I think it's Ndova versus Ndova. It's a very new case law that has come through. I don't think it's going to come through in your exam, but just in case, understand that case law has just taken place where a judgment, the judgment was this: we had a couple in community of property, and the court awarded 50% of the pension interest, obviously, to the non-spouse. And what the courts did not do in terms of that award was actually mention which fund the ex-spouse can claim on. Now, you remember all the cases we had up until now actually say that if there's a divorce order and I want to claim against the pension fund, it's got to specifically state what that pension fund, the name of that pension fund or provident fund, etc. And if the name is not there, the administrators generally send it back saying, please go and adjust this and have the name of the fund on it. Now, very interesting, in this particular case, in terms of in community of property, the judgment was that Section 7 of the Divorce Act specifically states that, not specifically, but gives an indication that if you're married in community of property, 50% is yours automatically. You don't have to go further and specify which fund you're actually claiming against. So here's a case that says if you're married in community property, it's just the only thing you actually need is a divorce decree that says you can claim against 50% of the pensionable interest, and the name of the fund doesn't have to be there. And I'm sure it's not Ndova versus Ndova, it's Ndaba versus Ndaba, N-D-A-B-A. That's the case for anyone who wants to go look at, but I don't think it's going to be in your exam, but I'd rather tell you. So she's comfortable from, well, she's actually not comfortable from a divorce. She must understand that her ex-spouse is going to take 50% of that fund. So can you see that Bella is going to have a problem? She might be very happy that she's going to divorce, but just like our example that we looked at, half of that is going to go. So you're going to have to start finding out how you're going to address the fact that that half is going to go. Important also is, from a divorce point of view, it only talks about marriage in terms of Section 7 of the Divorce Act. So the Divorce Act will not apply to long-term relationships and tenets of religion. Why? Because those are unions. It's not, you're not going to divorce. So the Divorce Act does not apply to them. So you must know now automatically, because it doesn't apply to them, any separation that we're going to have them, because they don't divorce, they're not going to be able to claim against pensionable interest. So if your client is in a long-term relationship, you're going to have to ensure that each one addresses their own retirement planning. Otherwise, there's going to be a massive impact in terms of retirement planning for that couple, which is very different to if a death takes place while I am obviously still married, and while I'm a member of a fund. That's important. I've got to be a member of the fund. Now, if I look at death in terms of the Pension Fund Act, there's two little sections that are very important. One is the definition in terms of dependent, and then, of course, Section 37C tells me how I'm going to distribute that, how the trustees are going to be distributing that, and Section 37D just allows for that particular deduction. And dependent is important because it tells you, I have basically three little blocks here, A, B, C, and D. It gives me three little blocks. The first little block says, do I have a legal duty, a reciprocal duty of support? If I do, then I've got a legal ability to maintain you in terms of dependence for death. Then I have de facto, that is my B. I might not be legally liable to maintain you, but you can prove You can prove that you become a dependent while I'm alive, so it is dependency. You can have to prove dependency. Then our last little leg is if you would have become dependent on me. Now notice what these acts are saying, because we want to go back to Bella and kind of go, based on these legislation, how does it impact Bella? So that's important. Then it does go and also give you a definition of spouse. Now important is that under legal, I do have spouse, and under dependent, I have spouse. So you've got to kind of work out, well, why is there spouse under two little legs? Because now I've got to go take a look at spouse and says, look, a spouse does mean I have made it wider to include permanent life partners or any other union, customary and tenants of religion. So I'm basically covering everything. So when would I have a legal duty to support, and when would I not have a legal duty to support? So your legal duty, reciprocal duty, comes automatic from an act that sets that obligation. So this legal duty that I have is obviously if I am married under any of my marriage acts. That is your normal marriage act, matrimonial property, civil union, customary marriages, and that's the ones that we have. So that is where I have that legal duty. The spouse under a factual dependence is those unions that are not recognized in a particular act. And that is my lifetime partner, and that is my tenants of religion. Those are still covered under spouse. We are going to recognize you as spouse, but of course you're going to have to show dependency. And then I've got if you would have become dependent. Now let's apply that if you would have become dependent back to Bella when we go back to the case study. That is very important to look at. Section 37C, I've just put that Section 37C for you to understand that the fund does not form part of the assets in an estate. I'm first going to look at dependent, and if there are dependents, I'm going to pay out. There was a question at the workshop, the face-to-face workshop on Monday, where someone sort of was concerned that someone had mentioned to him that if no dependents are found, then the fund goes straight into the deceased estate. That is not necessarily the case at all, because there is a particular process. If you go and take a look at the whole of Section 37C, there's a process there, and in summary it goes, the trustees, at their discretion obviously, the trustees are first going to be looking for dependents. If there are dependents, they're going to be looking at how they're going to allocate to those dependents. They'll also take a look at if there's a beneficiary nomination. So if I have dependents and a beneficiary nomination, they're going to look at dependents and beneficiary nomination. But of course, beneficiary nomination is a, well, last resort, if I can put it that way. Maybe I'm not saying it correctly, because I'm going to be looking at, should I be allocating, what should I be allocating to the dependents, and should I be allocating anything to the beneficiary at all? If I have no dependents, then I'm going to be looking at beneficiary nomination. So it becomes important to have a beneficiary nomination. So no dependents, I then look at a beneficiary nomination, and before I allocate my funds to the beneficiary that's been nominated, I'll go to the executor of the deceased estate, and I'll ask the executor whether there are any liabilities that may exceed assets. So I want to make sure that the estate is solvent first. If there are liabilities that exceed the assets, then I'm going to pay the liabilities first, and then what is left I'm going to pay to the nominated beneficiary. If there are no liabilities that exceeds assets, i.e. so it's a solvent estate, then I'm going to give the whole allocation to the beneficiary. It's only if and when I have no dependents whatsoever, I have no beneficiary nominations whatsoever, then the pension fund, the fund's value gets paid into the deceased estate. So that's the last resort. I will look at beneficiary nomination. When the amount gets paid into the deceased estate, the question is it estate dutable? I believe it becomes estate dutable most definitely. And will there be executive fees on it? I do believe there will be executive fees, because now all of a sudden the executor is going to have to deal with it. So I hope that makes a little bit more sense in terms of how Section 37C actually operates. So that's the pension fund. Let's look at this marital regimes and definition of spouse in terms of certain tax acts. Now remember, what I'm doing in this particular little clause here is I'm looking at Income Tax Act, I'm looking at the capital gains, which is the 8th schedule to the Income Tax Act. I'm looking at donation section 51, which is also part of the Income Tax Act, and then I'm looking at the Estate Duty Act. There's many other tax acts, but this is the one I'm particularly looking at. And this act is beautiful because it kind of says spouses, everything that you are living with, whether I am married, whether I'm not married, whether I am same-sex, opposite-sex, tenant of religion, doesn't matter. I recognize you as spouse from that perspective. And I think from a tax perspective, the only one to really consider, which will have impact on how you calculate, if that is something that you require, is your married in community of property. Because remember there, 50 mine, 50 yours, when it comes to income tax, clearly then what I'm going to be doing is I'm going to be taxed on passive income. Trade income is split. Sorry, let's redo that. Trade income is for that spouse alone, but passive income is split. I think it's also important just to mention when it comes to donations for a marriage that's in community of property, please just always be aware that if I'm making a donation, then of course, so if let's call it a husband, if the husband married in community of property is making a 500,000 donation, we do kind of automatically assume that it's 250 is it's the wife and 250 is his, and of course each one has their 100,000 annual exemption. But be very aware if perhaps that 500,000 is coming from not joint estate. So when will assets not be part of joint estate? Remember, if I'm married in community of property and my dad dies, etc., and in the will he says, I specifically exclude this particular asset out of any form of marital union, then that means that that asset alone is mine. So perhaps my donation is coming from that asset alone, and that is not a joint asset, in which case 500,000 is my donation, and I only have 100,000 exemption, and that tax is total just for that one individual. If it is joint, then of course you split that donation and each one gets 100,000 donation. So that's important. The other thing that is also important, and I know it's not tested in postgrad, but understand that in terms of PCE, it tends to be a far higher level than your postgrad. So just know that even though I'm married in community property, I have an opportunity to set up a contract where I specifically exclude certain assets. I can do that. So it's not only married with the accrual that I have the opportunity to say, look, I'm not bringing these particular assets into my marriage. In community property can also have that type of contract. So just look at the facts. If the facts stipulate that, then just bring in your knowledge and apply accordingly. But I need you to understand that that is also applicable. So if you see something like it, don't have a heart attack. Just go with the flow because you all have that knowledge. Then we've got the Security Transfer Act. I like trying to bring that up because there is no particular spouse definition, so I'm going to have to fall in because it talks about a spouse marriage. So I tend to go towards the general definition of spouse, meaning that I've got to be married, but it does go further to say dissolution of their marriage or union. So I'll probably fall under the Income Tax Act and go, it will include every single union as well as spouse under Marriage Act. Now I do bring in the Security Transfer Act because I find that more often than not a lot of financial planners don't know that it exists. And the reason why it exists is because remember, securities, if you go take a look at the Security Transfer Act, securities are shares or members' interests in a CC, etc. It includes that. It's got a lot of other things which you have to look at, but it includes that, which means that if I'm entering into a buy and sell arrangement, then shouldn't I take into account that I've got this act, this tax that I've also got to consider, and that is 0.25% of shares that are being sold. So in my buy and sell, I understand that if you're only doing a 1 million buy and sell, then maybe 0.25% is not major. And I'm sure the survivor of this buy and sell setup can go and find 0.25% somewhere. But if you're looking at a massive buy and sell, then that becomes important, not firstly, to understand that if I'm dealing with a spouse in terms of securities, there are certain exemptions, but if I don't have a spouse, if I have got someone that is unrelated to me, then there is an additional tax that I have to pay whenever there are transfers, disposal, etc. of securities, and that can be quite expensive. So I particularly bring this up so everyone understands that when I go into a buy and sell arrangement, I have to look at that particular tax. Transfer duty tax, here again they have a specific definition of spouse. Here it's just about everything again, and I think this is sort of what covers your Security Transfer Act. And because every time I change properties, etc., dispose of it towards for a spouse, then I've got a couple exemptions. And read these exemptions very, very clearly, because there are situations where even though you're a spouse, there is still going to be a Transfer Duty Act. So go and take a look at that as well. See, there's a lot of legislations that impact, or rather, your marital regimes actually do impact a lot of legislation. Or is it the other way around? I can't actually recall now. Okay, so let's look at Insolvency Act, and I'll summarize. I've given you quite a bit of sections in the Insolvency Act. I wanted to read that because a lot of times planners do come to me and say, no, that cannot be possible. It is actually possible, and it is actually true. So there's, I think it's more an absolute truth than it is a relative truth. But I have also double-checked this with a couple of people, because originally when I read this, I thought, oh no, this cannot be possible. But we've got a beautiful little act called the Insolvency Act, which I think sometimes is more dangerous than SARS itself. And this Insolvency Act basically says, I don't really care what type of marital regime you're in, and I don't really care if you're in any particular union. If one of the parties become insolvent, then the sheriff will attach all the assets, so yours and that of your spouse or of your partner. They will attach everything. Then it's up to the so-called solvent partner to show to the sheriff that, or provide the sheriff reasons on why certain of those assets are going to be returned back to them. So I always kind of go, can you prove that you are not party to the crime? How do we prove that? I'm sure there's many, many ways. But I kind of find it, there could be situations that could be very difficult. And for instance, what if I'm married out of commuter property, without the accrual? What if I am just in a long-term relationship and my partner becomes insolvent and I don't actually work? Just imagine that sort of scenario. Of course I've benefited from the proceeds of his crime, if I can put it that way. So I think it could be very difficult to prove. So from a financial planning perspective, I would make my clients very aware of that, especially if I know that one of them could potentially get into trouble from a creditor point of view. I would sort of alert them to that. So luckily, yeah, from our case study perspective, Bella's divorcing. So maybe that individual will no longer have an impact on Bella, but while she is still married, and if her spouse has not been such a saint, let's just go back there, if my spouse has not been such a saint, then obviously that's going to impact on anything to do with planning. Imagine if I have everything in my name, and then all of a sudden I have this spouse that has not been a happy chappy, and half of my assets go, or everything, and I don't know how to get it back. Okay, so that in itself is important. Let's look at law of succession. So I'm going to touch on interstate and testate. Interstate is if I die without a will, and obviously testate is if I have a will. And I think interstate becomes important to understand my definition of spouse. And if you look at the Interstate Act, now you'll notice in terms of your notes that I've given you, ladies and gents, the notes for law of succession, I know I'm only touching on spouse here at the moment, the notes for law of succession is huge, but there are particular reasons why I've given that to you. I don't expect you to go into detail if you have a general knowledge or a summary of what actually happens if someone dies without a will. But it goes on to say, from a spouse perspective, okay, I'm looking from a spouse perspective, it goes and says, if I die intestate and I have the spouse is survived by a spouse, and again is survived by a spouse, and then it goes, there's no definition of spouse in terms of the intestate succession, but it goes, general meaning of spouse for this purpose also includes. So can you see general definition of spouse? I've got that Marriage Act, etc. That's automatically spouse. Then it says it also includes the survivor of a Muslim marriage, because remember we've had two case law. We've had Daniel versus Campbell. We've also had Hussein versus, not Hussein, Adam versus Jacobs. Those are the two case studies that we've had, or case laws that we've had rather, that has changed the Interstate Succession Act to say that even though you are not married under the Marriage Act, we will recognize you as a spouse for interstate. And then we've had Burvis Magistrate that says if you are married according to the black customary law, then, and not according to the Marriage Act per se, then of course we're also going to deem you to be married or a spouse for interstate. But now that covers our Marriage Act, that also covers our union in terms of tenets of religion. The mere fact that it was Muslim, I believe that it leaves it pretty wide for any other tenets of religion to attack the Interstate Succession Act. So there I think it'll leave it pretty wide for tenets of religion. But then it goes and it says it will also include the survivor who had been in a permanent, so here's your long-term relationship, but same-sex relationship. So this is where Gary versus Colbert came in. So now it kind of goes and says, well, this is actually fine, because if you are in a long-term relationship, same sex, then we're going to cover you as a spouse. But if you're a long-term relationship, opposite sex, remember, ladies and gents, the Interstate Succession Act does not cover you as spouse. And this is why it's important that when you do see a client, long-term relationship, opposite sex, that a will is put in place. A will must be put in place, because otherwise, if you die without it, then your partner is not going to be recognized. Of course, we can sit and debate about, is it constitutional, is it not constitutional, but that's the way the Act reads, and this is how you're going to apply it to your case study. We actually have case, I think it was middle of last year, if I can recall, Loveship versus Dublin. This was a same-sex partnership. This was basically where the partner died, the executor was the partner's brother, and died obviously without a will, and the executor, who was the deceased brother, was not happy that his partner actually was going to inherit. He's said no, he's not going to distribute it according to the partner. He's going to exclude the fact that the partner was there and it's not a spouse, and he was going to distribute it upwards because there was no descendant, no spouse. This whole thing went to court, and the judge basically fired the executor to say, you know, you're being biased, and if as an executor you don't know what how the Act reads, in bad luck. But that was just confirming that same-sex partnership will be covered in terms of spouse for interstate. In terms of the Wills Act, the only bit that I can see there is, again, I've got a general definition of spouse, and it goes to say it includes a person who had been in a civil union and with the other person of the same sex. Okay, sorry, there's a comma. So I'm going to recognize civil union, okay, part of my Marriage Act. Includes a person who had been in a civil union in terms of Civilian Act with the other person of the same sex or opposite sex, whether in the form of a marriage or whether in the form of a civil partnership. You see, this one doesn't go further to include long-term relationships and tenets of religion. So why would I bring up a Wills Act? Because you can actually nominate whoever you want. If it's a long-term relationship, you can say, I want Carmen to inherit, and that's it, Carmen will inherit. But remember there's Section 2C in the Wills Act that basically says that if the beneficiary together with the spouse, if the beneficiary is unworthy to inherit, or renounces his right to inherit, then the spouse will inherit that person's start. So yeah, it nearly gives me the indication to say, well, only if you're a spouse that is recognized in the Wills Act will you get that. And it nearly leaves it open to say, well, if it's a long-term relationship, you are not spouse for Section 2C2, I think it's 2C2 of the Wills Act. So that is an interesting one to look at. But of course, one thing you will know if I have a Wills Act, a risk is if you leave out substitutions. So if you have the situation where someone fails to, or I either fail to inherit because I don't have the capacity to inherit, or I've renounced. If you have substitution, then of course I don't have to worry about spouse or no spouse. It's going to devolve upon that person. So I'd say something to the effect, I leave my assets to Carmen, but failing that, it goes to Tom, and failing that, it goes to Jane. I probably wouldn't have too many of those, but I would definitely try and cover it from that perspective. Then let's go to the Maintenance of Surviving Spouses Act. Here again, all over the Act, it talks about a surviving spouse. So, of course, it would be a marriage that's been dissolved, but then don't forget, as a result of case law, both Daniel versus Campbell as well as Hassan versus Jacobs, one being a polygamous marriage, the other being monogamous marriage, through case law, it has changed Interstate Succession Act as well as Maintenance of Surviving Spouses Act, where it allows those tenants of religion to also claim against Maintenance of Surviving Spouses Act. But it will not cover long-term relationships, whether you are same-sex or opposite sex. So on death, it becomes important to ensure then that I actually have a will in place. And not only that, even though I have a will in place, ladies and gents, to say that Carmen, who is my long-term partner, will inherit, remember the Maintenance of Surviving Spouses Act really assists where not sufficient assets or liquidity was left to the spouse in any event. So if I have a will that says I leave everything, well, I leave 40% of my estate to Carmen and the other 60% goes somewhere else, that 40% might not be sufficient for me. So I now have a recourse against the other 60% that goes to someone else by using the Maintenance of Surviving Spouses Act, and only obviously if I qualify, because remember there is a qualification type point of view under the Maintenance of Surviving Act that you have to actually look at. On the other side of the coin, if you have, which I haven't got in my documents, and I actually forgot to mention this at the workshop, so I'm hoping that everybody also listens to the webinar. Remember, we have a Maintenance Act, which is while I'm still alive. So that sort of kind of goes, well, the Maintenance Act would apply when I'm alive and my union is being terminated or my marriage is being terminated. Now, in terms of the Marriage Act, Maintenance Act, something that is very interesting is that is in the Act itself, it makes provision for anyone who has a legal duty to maintain. Okay, so the mere fact that the Maintenance Act has this, if you have a legal duty to maintain, then of course if you are in a long-term relationship, same sex or opposite sex, and you actually agree, you have an agreement where you agree that on the duty of support to your partner, then you can actually trigger the provisions in the Maintenance Act. I would much rather you have this agreement in place so that when there is a dissolution of your union, that everyone knows what is your obligation and what is your responsibility, than having nothing at all. Because the Maintenance Act says there is a legal duty, but if I'm just in a union and I haven't sort of cemented what our legal unity is, then legal duty is, then I think there may be a bit of a problem in terms of triggering those particular provisions. So an agreement becomes very important. I didn't mention this in the workshop. I haven't got it in my notes. I think there are many other acts. Note what I'm saying. I think there are many other acts that I have not covered in the material, and I might not cover in the webinar, but that doesn't mean that you're not going to be tested on it. So I think please make sure that you do look at all other acts. So now we've looked at that marital regime, we've looked at when you are spouse, when you are now not spouse. So as and when we go through this case study, let's just apply that knowledge back to our case study. Okay, so now we know she's married in commuter property, she's not yet divorced, but we now understand what happens if she dies before divorce and what happens as a result of divorce. Which acts are going to become applicable, which acts are not going to become applicable, and if she dies after the divorce in terms of now she's single, now she's probably, or she's going to go into a union, etc., what it's going to mean to our client Bella. She's got some dependents. Let's look at dependents. She's got a mother who is not dependent as yet, but she may become dependent in a few years' time. So what have we looked at? We've looked at a Pension Fund Act that has a third little leg, if you can remember. That last little leg says you can claim, if you can prove, obviously, dependency if you were to become dependent had this person survived. So clearly, yeah, if you had made enough notes and a death takes place before the 3 or 4 years has arrived, then the mother has an opportunity to lay her claim against the pension interest because she would have become dependent on Bella if Bella had to die now. She would have become dependent in a few years' time. So that is important to look at. Okay. I just want to go back here quickly. Remember, I need to go back here because I did forget this one. Remember that if I look at testate and intestate laws that we've just looked at, there's a bit of a risk here because if she dies now without a will, remember the will looks at are you spouse, without a will. The Interstate Succession Act looks at are you spouse at the date of death. They are not too concerned about did you divorce 3 months ago or did you divorce more than 3 months ago. Those 3 months is purely in the Wills Act. So if I have a will in place and leave everything to my spouse and I die within that 3 months, then my spouse is going to be deemed to have predeceased me, so my spouse is not going to inherit. But if I die just a day after my 3 months and I haven't adjusted my will, then of course my spouse will inherit. So that is important to understand, but know that from an interstate perspective, at the date of death, divorce has not been finalized, you're still married, so the spouse will inherit. And don't forget, please, that that greater of spouse and or child, that greater is now 250,000. It changed about a year ago. It's no longer 125,000. Let's go back to a dependent. She doesn't want her mother to move in with her. She wants her mother to remain as independent as possible. So she wants to buy a small apartment, which would have cost her $1 million today. And she also wants to ensure that her mother receives $5,000 a month until the age of 85. So this itself becomes a concern because if I have to die today, I need to make sure that the mother has sufficient liquidity to keep her going. And not only that, so I've got to plan 2 ways here. I've got to plan if there's an immediate death that takes place now, the mother must be looked after. And I'll also have to plan what if Bella does not die? What if Bella does survive? Then Bella has to have sufficient income, or rather sufficient liquidity and or capital, whichever way you want to look at, to ensure that she can fund not only the apartment that she wants to purchase, but obviously also the income that she's going to have to pay until her mother is 85. So that's something you're going to have to bear in mind. They also have a child, Pamela, who is 20 years of age, which is great. She's no longer a minor, but that doesn't mean that I'm not going to have to support her because she's still going to study for another 4 years, and that is the cost is going to be, they're going to have to save for. I can't even think of that word at the moment. They're going to have to ensure they've got 150,000 Rand a year for at least 4 years to keep her going. So of course, yeah, you're going to have to work out how much does the father, because remember there's still a legal duty for the father to keep the child going as well, but also take a look at what does the maintenance order say. Is the father responsible for some of the education fees or not, etc., and who actually has to cater for all this capital. But if it doesn't say so, if it doesn't say anything, then you're going to obviously have to make some recommendations to Bella, because again now I'm going to have to look at two aspects. If I'm still alive, I have to have this capital to keep my child going, but if I have to die now, then that's part of my estate plan, is do I have enough liquidity to keep Pamela going. She does not have a will in place, so she's going to die intestate. And she doesn't know how to put all this together, so you're going to obviously help her in the process. But what is her risk immediately? Well, is there a big risk? As I said earlier on, there could be a big risk here, because you must remember she's in the process of divorcing. If she dies without a will now, her spouse will get the greater of. And maybe I don't want him to get the greater of, because I would prefer my dependents to get that money, of course. But let's just assume for one sec that this death takes place after divorce. How does the interstate succession work? Remember, what I'm going to do, if this is the person that's died, what I'm going to do is I'm going to look at the side and say, is there a spouse? If there is no spouse, and or if there's a spouse, I'm also going to be looking at descendants. And if I have descendants, then of course my descendants are going to inherit my estate fully. If my descendants is not around at the time or unworthy to inherit, etc., then I'm going to be looking at the descendants of their descendants. So it goes down per stirpe. So in the case of Bella, the day after divorce, then of course we're quite comfortable because Pamela is going to get everything. But what happens to this poor mom? She's not going to inherit anything. We're not going to go up at all, because this poor mom is an ascendant and we've got a descendant. So Pamela will inherit everything. The mother will not inherit anything whatsoever. And now it relies on Pamela to look after her grandmother. And we all know how that works. We all love one another while we're alive, and then just wait until you die becomes a different story. So yeah, of course, your recommendation is going to be, this is a risk. Please let's put a will in place, and then we're going to do planning around that. So what I would have done at this particular point is I would have started immediately with life insurance, but because we've got about 6 minutes before we have our first break, I've got to stick this to the breaks because this is being recorded, so it does get interrupted for a sec. Let's just touch a little bit on this occupation bit, only this bit, and then we're going to take the facts that have been given to us, and then we're going to look at life insurance and taxation, etc. in detail. Then we'll come back, not necessarily come back, but then we'll just sort of pick up the facts that have been given to us in this particular section. And then when you come back from your break, we're going to be looking at pages 13 to 19, so you can take that out in the meantime. So she's a full-time employee at this particular training academy. She only has 40% shareholding, and the company's worth 10 million. So she's obviously got 4 million of that company. She says to you in this particular conversation, she says to you, she's got a partner not related to her whatsoever, and the partner holds 60%. So of course we're comfortable, because if Bella does, she's only got 40%. So in relation to Bella, we are not too concerned about a family company for certain legislation. But of course, if her partner had to die, the fact that the partner is 60%, we are a little concerned about in terms of her death. Will be a family company, but Bella's our client, and we're going to stick to Bella. And it goes on to say Bella only holds although Bella only holds 40% of the shares, their business actually revolves around her. She does everything there. Okay? Now, maybe that's not very important in terms of day-to-day running of that company, but some of the recommendations we're going to be putting in place and some of the legislations that govern those recommendations becomes important. The fact that this company actually runs according to when and how, etc. Bella jumps and says, etc. That's important. And that policy was taken on her life to the value of 3 million. Clearly, because of the fact that she's very important in the company, this is clearly a key man, which we're going to be looking at. the company is the beneficiary, so clearly there the company is going to benefit. We're quite happy with that. The policy is structured a little bit strange though, because it says the policy is structured where Bella is the owner. She's also the life assured. The company is the premium payer, the company is the beneficiary. Okay, so can you see the bit of a problem there? Because that is not totally structured correctly, so we're going to have to look at that. And the premium on this policy is $918, and you're going to have to look at it and say, well, could this, because of the fact that it's not properly structured, could this be triggering off a fringe benefit tax, which is very important. And remember your knowledge of last year, when the employer contributes something where the employee benefits, then I've got a fringe benefit that has to be raised. So that is a question. Is this structured correctly that can make tax inefficiently? Then she all of a sudden confuses you slightly, and she goes and says, well, Belle and I have a policy on one another's life for buy and sell purposes. Well, some of us actually on the workshops, it was very cute because some people went, who wrote this case study? Because, I mean, this is very confusing. How can we at one point kind of go, oopsie. And one point we're actually going, yes, the partners, they're not related to one another. Then all of a sudden, a sister turns up and they have got policies on one another for purpose of buy and sell. How does this actually work? And I think what we're going to do is we're going to just touch on that when we actually are going to be doing buy and sell when we come back after our break. Because I think it does talk about, your guidelines talk about business assurance. So we're going to touch on business assurance. And when Alon did her introduction on Monday, she had mentioned something about understanding all types of buy and sell structures. I didn't particularly see that in the guideline, but the mere fact that she did mention it, I kind of went, oops, let us just make sure we actually understand that. Because whenever something is said, I always think, what are they actually trying to tell us? And then, of course, Bella's got some health problems we've got to take into account, and they've put in a policy to the value of 10 million. Remember, she only has 40%. She only has 4 million rand of shares. So why am I putting something in 10 million when there's only 4 million that I need? I understand she's got health problems, but if she had to die immediately, what are the implications of this policy that is overvalued? If I don't have policies, ladies and gents, then it doesn't matter. But the mere fact that I've got a policy, it becomes important. So her partner's got cover for 6 million, and there are premiums that are being paid, but Bella's unable to obtain disability. So we're going to go on a break because we've got about 30 seconds before it's 10:15, and the recording will be stopped for about 15 minutes. So I'd like you back, please, at 10:30. This is a nice big break because I know the first hour is a little bit challenging. And when we come back, please have those particular pages open. And I mentioned pages 13 and 19 because those are the ones we're going to be tackling when we come back. Enjoy, take a big breather, go have some coffee, and I will chat to you soon. Okay, my apologies. I just got a little message from Kirsten saying we can't hear you. I thought I had unmuted myself, but pressed the wrong button and actually muted myself. So I do apologize. I was just talking about how quickly 15 minutes had disappeared, so you have not missed much. And hopefully now everyone can hear me and everyone can see my notes. Thanks a lot, Kirsten, for that little note. So now we've spoken about, or we've rather looked at Bella's little bit of occupation details. And now what we're going to do is we're going to be talking about all types of products that we have available and the taxation around those products, because if you take a look at your exam guidelines, it tells you right at the top, financial products, especially how financial products are taxed and the impact of those taxation on a client's financial plan, be it personal and or corporate. And then at the same time, what I want you to do is I want you to look at the second bullet point of your guidelines that says business entities, partnerships, and trusts. I'm going to try and cover both those points in a way, because I don't know if all they want is to test whether you know the regulations and the rules around business entities, how many partners must I have, how many shareholders can I have, directors, etc., and what is your succession, and those type of details. I don't think it's something they're going to test. I don't believe. But for those of you who are a little uncomfortable and would still like to take something into the exam, then I would obviously recommend, of course, there's details in your financial planning handbook, but what is also very good is the old mutuals, premium and problems. There they've got a couple of pages of tables on advantages and disadvantages. So take that in. But I don't think that they're just going to ask that type of detail. I nearly go, perhaps the fact that they are focusing on financial products and taxation, and it goes further to say from a personal financial planning point of view and a corporate financial planning point of view, I nearly am trying to see that perhaps these life insurance, not these products that I'm going to be talking about, is not only going to be a natural person who is the policy holder. I've got a feeling there's going to be a business entity that is also going to be the policy owner. And if it is different entities, how does the taxation work and how does it actually apply to planning for that entity? So I've tried to cover both, so I want us to think along those lines as well. Ladies and gents, I'm going to assume that because you have passed the postgrad, or perhaps because you have the qualifications to write this board exam, that you actually know a lot about certain of products, i.e. I'm not necessarily going to go into what whole life insurance is about and what disability is about, etc. But of course, if you are unsure, I'm going to expect you to ask those questions. So we start with long-term insurance products. Now that's important to understand, that I am covering products under a Long-Term Insurance Act. So this is what long-term insurers are able to provide. And the reason why I emphasize that is because the taxation on some of the products under the long-term insurance is very different to the taxation on products that are not under the Long-Term Insurance Act. So I'm specifically focusing on long-term insurance products at this stage. So I've got whole life insurance. Whole life insurance is a life insurance that gets paid out upon death. One thing that you can do with life insurance is, of course, you can put in rider benefits. What is rider benefits? Rider benefits is cover such as disability, dread disease, etc. So you can do quite a bit of that. I'm not going to go into that, with the exception of making sure that you understand that there's a difference between capital disability and income disability. Capital disability is more towards your permanent disability, but within that itself you've got occupational, own and similar occupation, all those things that you're going to have to understand. And of course, from an income perspective, some of us call it income replacement, others call income protection, and that is really so that if you are both, not both, but if you are either temporarily disabled because of some sickness, car accident, etc., or permanently disabled, okay? And every company has its rules in terms of income protection. Remember, your CISA guidelines don't exist anymore, but companies are still doing very ethically in terms of your cap at 75%, but they do differ. Some are 75, some 100, some depend on whether it's permanent, whether it's temporary. And I think the most important thing for you to remember, obviously, is that contributions to an income protector are no longer tax deductible, and the income that pays out from income protector is no longer taxable. Okay, so that's the only difference I want to point out. But in your notes, you've got everything about rider benefits. Please go take a look at that. I'm not going to cover it now. So if I have life insurance, look at the tax bit of it. If I have life insurance and I take it in my personal capacity, i.e. I'm the policyholder, I'm generally the life assured, or even if maybe my spouse is the life assured, but whatever this policy is for, it's for a personal need, a personal goal. So from an income tax, we look at the contributions to these policies will obviously not be deductible because it is not income, it is capital in nature. So contributions towards a policy is not deductible from an income tax perspective, then it obviously makes sense that because it's not deductible, it's not in production of trade, then perhaps the capital that pays out is not income in nature and it's capital in nature. But remember, your 8th schedule, capital gains tax schedule, you might find it very surprising that where you look at the definition of assets for capital gains, it specifically includes life insurance policies, investment policy. It includes it. That means that life insurance policies is an asset for capital gains tax. But if you look at paragraph 55 of the 8th schedule, there it lists all the insurance policies. The payout would not attract capital gains, i.e. it's exempt under certain circumstances. So if you are not sure which policy attracts CGT and which one doesn't, please just have, it's a one-pager. If you download paragraph 55 on the SARS website, it is there so that you understand. Now, one thing that they did 2 or 3 years ago that was just perfect for us is that they introduced a section, I think it's paragraph 55F, that says if you have a risk-only policy, it will never attract capital gains tax. And that's something you remember all the time. If I'm dealing with a pure risk policy, I will never have a capital gains tax problem. But what I'm going to touch on is, but what if the policy does has a cash value? Okay, because I think you need to understand that other part of it as well. What if there is a cash value? Then paragraph 55 1A goes a little further to say, if the policy pays to the original beneficial owner or to the spouse or nominee of the original beneficial owner, then it's also exempt. So if it's risk only, we smile, we don't have to worry. But if it has a component of an investment, remember the old universal type policies had an investment component, then I can't go risk only exemption. Then I have to ask myself, is there anything else that will help? And remember, if it's paid to the original beneficial owner or to the spouse, nominee, etc. of the original beneficial owner, then I also don't have a CGT consequence, which is great. Now let's look at a state duty. This was an automatic assumption I made at the workshop, but I understand that there's still some confusion in terms of this life insurance policy. And if you look at the Estate Duty Act, there is a nice little definition of a domestic policy as well. But if you look at the deemed property section of the Estate Duty Act, it goes and it says, if I have a life insurance policy, it must be a domestic policy. So look at the definition of domestic policy in the Estate Duty Act. It is on the life of the deceased due and payable. So can you see it's not concentrating on ownership. It's concentrating on, are you the life assured? Firstly, is it a domestic policy? Are you the life assured on that policy? And on your death, does it become payable as a result of your death? Now, we're going to see a situation where that due and payable on your death is quite applicable. So I also get then asked, well, if I'm only concentrating on life assured, then why, if I'm an owner, it's included? Well, you must remember this is the definition, not the definition, the requirement of a life insurance policy under deemed property. If you are an owner of something, then that is property. Prior to death, you own that. But now we have to think of it this way, is, of course, now I have to look at, is this policy risk only? Or does this policy also have some form of cash value? Because if I'm an owner on a policy that is risk only, then clearly there's nothing that becomes payable. Would you agree? There's no, the fact that I die doesn't mean that the policy now pays out, because the policy is only going to pay out when the life assured does. The executor now becomes obviously the owner of that policy, because the executor sort of takes your sort of legal stand on that policy. But there's nothing that's included. But if that policy has a cash value component to it, so if I'm looking at an investment type policy or a life insurance policy with a cash component, then it is the cash value that goes into property for estate duty purposes. Okay, so just remember that. So this life insurance policy becomes dutable. What you've got to do, because this is a policy I take on my personal capacity, and I'll kind of go, in the State Duty, are there any exemptions in the State Duty Act for this type of policy? No, there is no exemption. So this policy most definitely will attract state duty. But of course, don't forget we do have Section 4Q deduction. So if that policy is payable to your spouse, then I have a 4Q deduction. But let me just, I might be lying here. I'm not lying. I'm actually perhaps summarizing it too much. Remember, I've got three exemptions. My apologies, that should be one. I've got 3 exemptions for estate duty purposes. I've got my key man type requirement, I've got my buy and sell exemption, and then I have this little exemption that says that if in my antenuptial contract I've agreed that I will take out insurance for the benefit of my children and or my spouse, it will be exempt. We don't have to stress too much about spouse at this stage because I still have a Section 4Q deduction in the state duty. I might not have it when I look at the Davis Commission recommendations, but I do have. But of course, if this was for the benefit, if this personal life insurance was taken out for the benefit of my children, then I do have that exemption in the State Duty Act. Of course, we've got to remember that. But otherwise, these type of policies are not exempt. And that's sort of your tax implication on that. What if I take this very same life insurance policy, because this is all it is. We talk about key man and we talk about group scheme and we talk about all these fancy little names, but what is it? It's really just a life insurance policies that we've implemented, but we have made it for a particular purpose. And what if I have employer-employee relationship and this policy was taken out? I call it for services rendered, but let's think of it this way. I can have in my company a form of group scheme which clearly has no pension component. It can also have a pension component, but here particularly I'm looking at group scheme that is not part of a pension. So this is an unapproved group scheme, and the employer pays the contributions to this policy on the behalf of the employee, and the employee benefits. So now notice I'm going into both a personal capacity as well as a corporate capacity, because there is 2 tax implications. One for the employer, where the employer is making these contributions, then the employer can, under 11W1, deduct the contributions that they're making. But before they can utilize 11W1, they have to, whether they use 11W1 or not, doesn't matter. They have to raise a fringe benefit for the employee. So company can deduct, and at the same time, a fringe benefit has to be raised where the employee is going to get taxed. So now notice the tax implications for the employee. I'm going to go home with a little less cash. So that's going to affect my budget. Okay, so that's important. When the policy pays out, it's going to pay out to the employee. Very few life insurance policies that have been implemented by the company to benefit the employee, very few of those policies pay out to the employer. More often than not, those policies pay out directly to the employee. When those proceeds are paid out, it is most definitely part of gross income for the employee. But then don't forget, I do have an exemption, and the exemption says if it's risk only, and a fringe benefit was raised from the date of commencement of from 1st of March 2012, and or if the policy was taken out at a later stage of date of commencement of that policy, then the proceeds come in and the proceeds go out in terms of the exemption. But if a fringe benefit was not raised on those particular dates, then that policy becomes income taxable. So maximum at the stage is my 41%. Now this is very important from a planning perspective, ladies and gents, because when you're doing planning from an estate perspective, remember if the policy is worth, if the sum assured on the scheme is worth R1 million, you're going to take that R1 million, pump it into F&A, and you go, don't stress, your dependents, beneficiaries, etc. have a lot of liquidity to keep them going. But if you have not asked or pulled out from your case study the fact that perhaps a fringe benefit was not raised, you're going to lose out on maximum 41% that is going to get taxed. So there's now a problem from a liquidity point of view. And then what else will happen? Remember, these life insurance policies and unapproved group schemes, the policy is dutable. It is dutable. So if I don't have a spouse as a beneficiary to take advantage of Section 4Q deduction, then not only do I have an income tax consequence, but I also then have an estate duty consequence. That is, I also have an estate duty consequence. So this R1 million is going to perhaps only be now 300,000 bucks. Okay, 300,000 rand. Can you understand? That's tax implication when you do planning. So you need to understand what is going on in the background and what type of information you have to ask. Very important. Then again, risk only, I don't have a problem in terms of capital gains tax, unless, of course, there is a oh my word, if it's a cash value. But generally your group schemes don't have cash value, so I don't think you have a concern there. From if it does have a cash value, then of course I have a CGT implication, but it goes into a big legal argument based that although the owner of the policy is actually the employer, because it's a scheme, it's deemed to be the employee that is the owner because of all these fringe benefits, etc. In their case, I'm still paying to the original beneficial owner. So that is if there is an employer-employee relationship and a policy was put into place for the benefit of the employee. What if we now take this very thing and go into key man? Remember, Bella has got what we think is a key man. It's just not properly structured, because a policy that is for key man should be structured where the company is the owner, the company is the payer, the company is beneficiary, and Bella is the life assured only. So it's not totally structured correctly, so we may have certain problems. So let's go through the tax legislation and then decide what problems Bella probably would have. So here again, employer pays contributions. Employee is then allowed to deduct those contributions from their income under 11W2, but remember, requirements have to be met. And what are those requirements? Firstly, it's got to be a risk-only policy, important. The minute I've got a cash component there, then it does not meet the requirement. So it's got to be risk-only. It's got to be owned by the employer at all times, and it's got to be for the purpose of the death, disability, or severe illness of the employee. And then if that is allowed, then if those requirements are met, then of course I've got a potential to deduct. I don't have to deduct. Okay, so you can debate whether it is good to deduct or not. That's totally up to you, but it's not an obligation to deduct. You can if you want to. But remember, no fringe benefits will be raised, where over here you have a fringe benefit consequence. Here you have no fringe benefit consequence whatsoever, because it's not for the benefit of the employee. And that's why you've got to be careful on how it is structured, because if it's not structured correctly, it could be seen as if the employee is going to benefit, and if no fringe benefit is raised, then obviously you've got some problems with SARS. When the policy pays out, in this case, of course, the policy is going to pay out to the company, because that is the intention, is for the company to benefit, so the company can replace that particular individual. It will be part of gross income for the employer. Most definitely it comes in, and then the question is, does it come out? Now, if the contributions were not deductible, then the proceeds are exempt. So it will come in, and then the whole setup is exempt, so no tax implications whatsoever. But if the employer did take advantage of 11W2, then of course comes in and it gets taxed accordingly. And if it does get taxed accordingly, what is it that you have to consider? Well, when you cover that key person for a particular amount, remember there's certain valuation that you can utilize, and the company definitely requires 1 million to work with, then you're going to have to up that policy with tax. 28% you've got to up it by, because that is first going to be taxed, and then what is left the company is going to be using. Okay, so that's important. Again, I don't have a capital gains tax consequence because it's risk only, but if I did have a cash component to it, what would happen is it would be CGT free if 11W was utilized. If 11W was not utilized, then I have a potential capital gains tax if there's a cash value to it. So remember that. Is this policy estate dutable? Again, I do meet these requirements, so it does become estate dutable. But now remember, I do have that exemption, okay? And that exemption is it's taken out on the life of the director, employee, etc. Premiums were not paid by the deceased. It was not on the deceased instance that the life insurance had to take place. And of course, that it's not going to be to the benefit of the employee's deceased estate or their dependents. If it's correctly structured, then I've got an exemption. But remember, it goes on and talks about as long as it's not a family company in relation to that deceased. So let's just apply that a little bit to Bella, because of course it is not a family company in relation to their deceased, because directly she only has 40% shareholding. But if you look at the definition of family company, you are going to find that that definition is pretty wide, because it firstly says if at any one stage it was a family company. So you'll have to do a little bit of inquiry to say, Bella, how was this company set up? Perhaps she was the 100% shareholder 20 years ago, and now that you're meeting her at the age of 53, she's got 40% because over the years she's sold off her shares to her partner, to whoever. So that becomes important to understand if it was ever a family company. But then it also goes further to state, directly or indirectly, or any potential of being in control of. So if you look again at the case study, does it not say that the business revolves around her because she's the decision maker, she's the strategist, she does the implementation, she does the marketing, so she does everything. So the fact that she has 40% is irrelevant. So it sounds like the other shareholder is not really active in the day-to-day running of this business. So does she not have this element of control? If she has this element of control, then perhaps it is a family company as per the definition, which means that this policy is not exempt from state duty. Who does the state duty when that is the case is always the beneficiary. So here the company, all of a sudden you sold them a policy of only R1 million, because that's what they needed. There's going to be no income tax implication in terms of how you have set it up. But all of a sudden, this company's got to find 20% to pay state duty. So that type of information you have to pull out, and it was given to you in the case study. Bella holds 40%, but this is what she does, and you've got to know immediately, I've got to look at state duty implications. Okay, so that again does not necessarily affect Bella directly, because although it is estate dutable, it is the beneficiary, the company, that has to pay state duty and not Bella. But you've got corporate problems, you are eating into companies' assets. Perhaps that's something not what you want to do from a corporate planning perspective. That's what you've got to look out for. And we can also use that very same life insurance policy, because this is all we do is we use a life insurance policy, and perhaps we're going to implement it from a buy and sell purpose. So let's just look at the requirements of buy and sell in terms of some legislation. Then we're going to go back to Bella and say how and why did she structure. Sorry, some of these questions do pop up. I'll get to that question in a sec. So perhaps we should look at how Bella and her sister all of a sudden structured this buy and sell. How does it work? Remember, this is information given to you, and you're going to have to decipher what is actually happening with that client. So let's look at these requirements. The contributions that are paid by Firstly, let's just make sure we understand what a buy and sell is. This buy and sell doesn't affect the company whatsoever. So I don't have to worry about family company at all. This is just shareholders. In this case, let's just keep the shareholders, and I'll take it a bit further, that have shares in this company. Maybe they're employees, maybe they're not employees. It doesn't matter in this stage. And they have shares in this particular company, and they just want to ensure that when something happens to one or the other, that they are given the opportunity to buy the other one's shares. Well, as not a matter of fact, the agreement obligates you to buy one another's shares. And you can just have the agreement. You don't have to have life insurance to back up this agreement. So if all your clients have is an agreement, that is fine. Life insurance just kicks in terms of, let us help ensure that there's sufficient cash, liquidity, so that you can buy those shares. So you don't have to perhaps go to the bank and ask for money, or that you don't have to go to your own personal investments to utilize that for the buy and sell arrangements, okay? And it's only if I have it's only if I fund my buy and sell with life insurance that I really have tax implications. Besides the selling of the shares, that's not what I'm looking at. The minute I sell the shares, and clearly I've got a capital gains tax consequence in any event. So it's just shareholder paying the other shareholders premiums. So can you understand that contributions are not going to be deductible because the shares are capital. So I'm paying something to purchase capital, therefore not income. Again, we take a look at, well, it does attract capital gains. Is it exempt? Again, if I look at my 8th schedule, if it's risk only, it will be exempt, but I have to sometimes question on why we have risk-only policies for buy and sell, because perhaps all we do, and this is important because Lalonde did mention buy and sell structure, so I need to go through this. I think more often than not, all we do is we kind of think of, oops, when you die, what's going to happen with your shares? But we've also got to perhaps look at when there's a disability, perhaps when there's a severe illness, you decide. But what about retirement? Perhaps I want to retire. Maybe Bella does want to retire at the age of 55 or 60 or 65, whenever it is. And maybe she doesn't want to have to hold on to her shares. She'll probably will retire as an employee, understandable. And maybe she still wants to receive dividends from her shareholding. That is also understandable. That's something you've got to consider in terms of your recommendations based on perhaps what is happening with your client. But maybe she doesn't want to. Maybe the agreement says, when I retire at the age of 55, wham, bam, I want to get rid of my shares. I want to go to Mauritius, sit there and not have to think about anything. Actually, I wouldn't want to go to Mauritius, but little example. So maybe I do want to have a type of cover where it has a component of risk as well as investment. Okay. So if I have risk only, there you are. Risk is gone because of my risk-only exemption. But what if I have capital as well? Well, now you've got to look at other exemptions on the fifth schedule. And there is a buy and sell exemption, whether it is as a result of death or whether it's as a result of a termination of your partnership. There is a buy and sell exemption there that you can take advantage of. I think one of the things you need to go and understand is, but what if I terminate my partnership or company, etc. And now what you have is you've got this sort of thing. You've got A that is paying for a policy in the life of B, and you've got B that is paying for a policy in the life of A. So perhaps what you want to do is, when this partnership has ended, you want to see these policies back to one another. So A becomes the owner of the policy on his life, and B the policy on his life, her life, etc. At this termination, I do have an exemption under the 8th schedule, assuming my policy's got cash. If it doesn't, if it's risk only, I don't have this problem, okay? But now, when A does die, am I paying to the original beneficial owner? You'd automatically think no, because the original owner was actually B and not A. But strange enough, the buy and sell exemption at this point actually takes it a little further, and it extends to when that policy actually then pays out eventually, and it will be deemed that A actually was the original beneficial owner. Only problem is, of course, if I enter into another buy and sell at a later stage, and then A uses that policy to cede it to C, and A dies and then it pays C, then C is obviously not the original beneficial owner. Then you've got some problems there. But I'm not so sure that exams will go into that detail. I think they will pretty much keep it to risk only, but at least you know that that exists, okay? Policy is definitely dutiable. Now you've got to take a look to see, is there a exemption? From that perspective, yes, there is an exemption, and of course my exemption is at the date of death. There must be a link in terms of partnership, shareholder, etc. The intention is to buy that person's shares, and the premiums were not paid by the deceased. And then it has a little extra requirement there that says if you are using the very same policy to also cover a loan, then the exemption will also cover that implementation, but only if it's company, not partnership. So be very careful in recommending that a loan of a partnership is also included in the buy and sell, because then you're going to fail the requirements of estate duty. So there you have it. Now let's just apply this back to Bella, because it seems like even though she does have a partner that's not related to her, why would I go into some form of policies with Bella? So let's start off by this. Am I obligated to only go into a buy and sell with my partner? I don't think so. Firstly, in terms of partnerships, I can go into a one-sided buy and sell. Okay, maybe Bella's the only one who wants to sell and the other partner perhaps doesn't want to sell. Maybe Bella does not want to sell it to her partner. Maybe Bella would like her sister to get those shares. So I've got a choice. I can bequeath it to Bella, to my sister in my will, okay? But that itself can be risky. Why? Because if there's liquidity problems in the estate, because we haven't dealt with it, then can you understand that maybe the sister will not get the shares? Although, of course, there's rearrangements, negotiations, etc. But that is a risk. So what can I do? I can go into an agreement with my sister so that when I die, money gets paid to her, so she has the possibility of buying out my shares. So I do have that one-sided. There's nothing wrong with that. But what you've got to look at is, firstly, of course, from an insurer perspective, is insurable interest. But we're going to assume insurable interest always exists. The only thing that would be concerning there and doesn't stop it, your buy and sell is not stopped because of this. The thing is, you are not necessarily going to have the state duty exemption, because at date of death you are not the partner or member, etc., which the sister clearly is not. But otherwise you can set up that type of buy and sell. That's not a problem whatsoever. Yes, you can question, if you go back to your case study, I think it said something to the effect that the sister, the life, we've got a partner in one another's life, okay, which means that I understand the reason why the sister would have a policy in the life of Bella, because Bella dies, money gets paid out of the sister, I can buy out the shares. But maybe I don't understand the other way around. But that is something you'd have to include in terms of your recommendation is it necessary, if Bella does have liquidity problems from a budget, expense, etc. point of view, is it necessary for Bella to have a policy on the life of the sister? What is that actual reason? Because it's not a true buy and sell. It's not because the sister has no shares, but maybe there's another role that the sister plays, and that's something you're going to have to look at from that perspective. Okay, so I hope I've covered, there is one thing, another structure that you can look at. And this is, let's look at this. Bella only has 40% and her partner's got 60%. If Bella has some form of liquidity problems in terms of her budget, remember the premiums on 6 million is going to be far higher than premiums on 4 million, and maybe Bella just cannot afford that. So what other way can I do? Remember, I can go into share buybacks. I'm explaining this purely because Leland mentioned buy and sell structures at the workshop. Maybe it means nothing, but I'm going to rather mention it than not mention it. And remember, one way of doing it is a share buyback. Okay, so of course you've got to look at the Companies Act, and I'm just trying to remember this. I think it's section 44 of the Companies Act that tells you certain requirements, 44, 45, certain requirements that have to be met, solvency ratio, etc. And if those requirements are not met, then you can't go into a share buyback. So there could be some problems there. But of course, this is a structure. So what happens is the company takes out a policy. So the company becomes the owner of the policy. On the life of that shareholder, company pays premiums, company is beneficiary. Again, I don't think there's a fringe benefit implication whatsoever. Well, is there not? Because is it for the benefit of the employee? No, I don't think so. I don't think it's for the benefit of the employee, because remember, the employee, shareholder, is going to be selling those shares anyway, and they're going to be getting that cash. So having this policy is not like as if the employee shareholder is going to benefit, because I'm going to get cash for the return of shares. So I think from that perspective, we're quite comfortable. Can the company deduct those premiums? No, I don't think the company can deduct those premiums, because I'm buying back shares. It's not a key man type situation. But what happens is when this partner dies, then the directors of the company, and then of course share premium gets cancelled. I now only have 40 shares that are issued. The fact that 40 shares are issued, the other 60 have been cancelled. Now of course Bella becomes the 100% owner of 40%, so she now has obtained the company, the equity of the company. There are unissued shares that can then be issued to someone else at a later stage if that is necessary. I won't have an estate duty exemption, and the only thing that will be CGT will obviously be the selling of the shares. But when I talk about CGT selling the shares, remember that's not totally and utterly true, because I've got to look at whether directors have decided to reduce contributed tax capital. If to the extent that the directors have reduced contributed tax capital, then I have a CGT consequence. If the portion that has not reduced CTC, then it's all dividend. Okay, so this payout policy proceeds are received. The directors decide whether they're going to reduce CTC or not. If they don't, then the payout will be a total dividend, and the deceased estate will only pay 15% dividend on the sale of those shares, because it's seen as a distribution. But if the directors decide to reduce CTC, then of course the part that has reduced CTC is deemed to be a capital disposal, and therefore there will be a capital gains tax. So just go take a look at it, because that does make a bit of a difference in terms of taxation. I think at one stage, I'm just trying to figure, I think at one stage dividend was cheaper than CGT, but I think at the moment the CGT effective rate is higher than dividend. So that is the type of thing you want to look at. So there are those type of structures, and also just be aware when you have a buy and sell with trust from an estate duty point of view, in one of those instances the policy is not exempt from duty at all. Okay, so let's look at using the very same life insurance policies, because we're still stuck with life insurance policies, and I'm implementing it for a contingent liability. So contingent liability can be many things. It could be that I stood surety for the bank. It could be that I've loaned the company owes me money. It could be the other way around. So you'd have to look very closely in terms of how it is structured, because I think it makes more of a difference in terms of the state duty exemption than anything else. Again, contributions to that policy is not deductible because it is capital in nature. It's not for trade. I'm covering a loan, or I'm trying to cancel surety, etc. So it's not income. Capital gains, we're going to repeat this very same thing again, risk or original beneficial owner, so I don't have to cover that. And what about exemption from a state duty point of view? Remember that potentially the only exemption I can use is what we call our key man exemption. We call it key man because that's more often than not when it applies. But let's look at this. It could be a policy not at the instance of the deceased. Let's just say the company owes Bella money. Okay, company wants to make sure that when Bella dies, executor can call in that loan and the company doesn't want to sell its assets, or the company doesn't want to delve into the investments that they have. So they take out a life insurance policy on the life of Bella, they pay the premiums, and they are the beneficiary. So let's go through the requirements. Not at the instance of Bella. Bella doesn't pay the premiums. So the last one, and let's forget about family company, because there is that family company requirement, of course, that you have to look at. So it goes, does it benefit the employee, the deceased estate, or its dependents? Well, maybe in this particular case, no, because the company does owe Bella money. So the deceased estate is going to get that money one way or the other, whether it comes from proceeds of a life insurance policy or whether it comes from a savings account that the company has. So I'm still going to get my 1 million. Doesn't matter how it is funded. So I think maybe we can squeeze it in. But if it's the other way around, where the deceased owes someone money, surety, etc., then I think life insurance will benefit the deceased or the deceased estate. Why? Because I now don't need to take 1 million out of the deceased estate, therefore reducing my inheritance, liquidity problems, etc. So I take this life insurance to ensure that it's only that policy that pays out to the bank, etc. So consider that. Those are those requirements that you can look at to say, well, can I utilize it? Can't I utilize it? Now, under whole life, I've been talking about mainly single life, okay? But we still do have joint life insurance. I know a lot of people look at me with the squint in their eyes, like kind of go, why would I do joint life? I think more often than not, there's still a lot of space for joint life insurance, and how it would work basically is, and I kind of look at it from this perspective. If I've got a couple, they are my clients, they have got a bond with the bank, and they say to you that doesn't matter who actually dies, I want to make sure that this bond is covered. So what are we going to do? We're going to take one policy for her and another policy for him, and the main purpose of this policy is that whoever dies first or whoever dies last, depending on what the requirements are, then this bond is cancelled. Well, we can do that with one policy, which saves your client quite a bit of money. I believe I've looked at some of those premiums, admin fees, etc. So I can take one policy, and that policy can say, on the death of the first dying. So whoever dies first, the policy is going to pay out, and the bond is going to be covered. So yes, the policy is dead and gone, which can be another question of whether it's ideal or not, but at least I've covered the purpose of, or rather the goals, etc., the concern the client has. Now, I don't have to go through in terms of the tax aspects, etc., because that's the very same as a whole life insurance, but in terms of the state duty, remember we have those requirements. It says, as a domestic policy, I'm happy. On the life of the deceased, I'm happy, but is it due and payable? So if we have this type of policy that says, on the life of the first dying, the policy pays out, then on the life of the deceased, it is due and payable, then of course I have then the policy is actually estate dutable. But if the contract says that it will be paid on the last dying, that means that when the first dies, is it due and payable on their death? No, it is not. Therefore, it is not dutable at that point. So that's why sometimes that is actually quite a nice policy to have. The other thing you must remember is it talks about a domestic policy, and if you look at, and this is for life insurance in the whole, if you look at the definition of domestic policy, it makes reference to products under a long-term insurer. So that means that if you have life cover to, let's say, cover things like car, even a bond, I suppose, but if it's not registered under the Long-Term Insurance Act or governed by the Long-Term Insurance Act, then of course it's not dutable. So if I take a life cover under the Short-Term Insurance Act, then it's not a domestic policy as defined, so now it's not dutable. So you see, I can save a little bit of estate duty. But the other thing you must remember is, if it's not dutable, the chances are SARS will not allow the liability as a deduction. So have I saved state duty? Have I not? I don't know. It's something that you would have to consider. So why do I bring group life into account? I think it's only because what you need to understand is that this group life is, all it is, ladies and gents, is individual life insurance policy. So you have this little umbrella. And under here, I have a whole lot of little life insurance policies, and it's for the benefit of the employee. So when the employee dies, etc., it will pay out. Is there anything different in terms of what we've spoken about? No, there isn't. Okay, because the important thing is to make sure that what you're talking about is unapproved cover, because unapproved cover will run exactly as a normal life insurance policy that we've spoken about already. The thing is, if it is an approved cover, i.e. all this risk forms part of a pension and or a provident fund, and even if I have an individual retirement annuity with a life covenant, then it works very, very differently, because the payout becomes part of my lump sum taxation rules. You know that withdrawal and or retirement and or, well, the death is also part of retirement lump sum taxation. So it doesn't follow the normal tax aspects that we've just spoken about. It goes into lump sum taxation rules. The contributions paid to this fund by the employer can deduct, and remember we had a 20% rule in the Act. It was actually 10%, but we allowed 20%. That has been done away with, so the employer can now deduct everything. It doesn't have to limit itself to 20% of payroll. So that's important. It is not estate dutable at all. These funds at this stage are still not estate dutable. Seems like it's something that the Davis Committee wants to look at and say, should we not make it dutable? At this stage it is not, nor are the annuities that come out of the sources of fund source. So we're comfortable from that perspective, and also the payout that pays out does form part of gross income. That is something that I was asked. It does form part of gross income, but it's not taxed according to income tax, it's taxed according to lump sum taxations. Sure, we still have a few minutes to go before, so let's continue going. So that is life insurance, and we're now going to go into term assurance, which is identical to life insurance. The only thing it has is not for life, it is for a term. Some of these things again are used for bonds, etc., because your bond's only for 20 years. Why do I want to cover you for life? After 20 years the policy ends. It's a cheaper form of policy to have, but from a tax perspective, everything is identical to what we've spoken about. Now we come to the beautiful endowment. Endowment and or investment products. Now endowment can be investment only, or it can be investment and life. Okay. So if it's endowment insurance with a bit of life, I think the tax aspects are very similar, with the exception of, now I want us to look at this bit, because you notice that what I've said here is that let's just look at here, because the tax aspects for endowment insurance is similar to endowment insurance with life, similar to endowment insurance that's just investment. I hope that I said that well. It sounded very confusing. Okay. Remember, long-term insurers are taxed according to the Income Tax Act, Section 29A, and they have a five-fund approach. And I know you know the five-fund approach. I've got the untaxed policyholder fund, I've got the individual, I've got the company, I've forgotten what the other three are. Oh my word. I know there's one now for insurance, but it doesn't matter. Please go take a look for us. I've just forgotten it, and I'm going to spend time trying to sit and remember it. We're going to concentrate on three, really. It's the untaxed bit, it's the individual bit, and the company bit. Those are the three that I'm going to be concentrating on. Each one of them are taxed slightly differently, but this is governed by the Income Tax Act. It says the insurer will tax the fund accordingly. So the tax obviously happens in the fund, and that's why we can comfortably say to the clients that when your policy matures, it will be free of tax. I just hope we also tell the client that it is free of tax when we pay out, but it has been taxed in the fund. Why do we want to tell the client that? Well, besides the fact that it's ethical, just remember, a lot of times I hear clients go, oh, but the particular investment fund that I selected, look at this, the fund fact sheets or whatever says it's performed at 20%. But that's not what I'm getting. And you're going to have to explain that, of course, there's costs involved, etc. But that 20% is taxed in the fund. That's why you're never going to get that amount of growth, okay? Of course, it helps to cover the taxes, but that is not what the client is going to get. And that's important for them to know. So let's just look at how it's taxed. If I am a natural person, i.e. the policy owner is a natural person, then from a capital gains tax perspective, there's a 40% inclusion rate, and all the income, etc., is taxed at 30%. Now, fund has no rebates, no exemptions, etc. So whatever comes in is going to be taxed. Dividend, obviously, at 15%. Okay, whatever comes in is taxed. Now, what you've got to look at is you've got to go to Bella, and you've got to go and say, Bella, Bella does have an endowment policy, okay, which we're going to just touch on a little later, but she does have an endowment policy. I have to now look at everything she earns, because she, I know she's 700 Rand. Let's just leave that one out for a sec. Everything she earns, does she have interest, does she not have interest, etc. Because if you look at I've got an endowment example, all these things will be available on the web. And I say, if that endowment that Bella has, if that only earns interest and dividend of 20,000, and it's got a taxable capital gain of 200,000, bearing in mind that this is now being taxed in the fund, then the tax liability of her profits, 45,000. Okay. Now, if I had to take that very same amount of money and put it into another vehicle that's not under the long-term insurance, how would it affect Bella directly? Okay. So what I do have, and I didn't even put the 3,000 in here. I didn't even put 3,000 now. I should add 3,000 to 45,000. So she's got the very same income that the fund has, but remember, she's got an interest exemption. The dividend is exempt, although there is dividends tax of 3,000, which I added here. I didn't actually add it there. And her taxable capital gain has got a annual exclusion where the fund doesn't have it. So her tax that she's paying is 5,736, a big difference, okay? So you have to sit and question whether an endowment is actually beneficial to your client on hand. If your client has loads of investments and she's already utilizing her interest exemption, etc., then maybe it's on par. But if you have a client that has no other interest, etc., maybe it's not ideal to go into an endowment. Okay, so that's why you have to understand the taxation of these funds. We tend to overlook it because when it pays out, it's tax-free, but it's important to go take a look. If the investment is anything other than a person, so we're looking at a company, etc., and not a trust, okay, I'm not looking at a trust here, then of course it's 28% income tax and 80% inclusion. So of course the question can be, why would I go into an endowment? Why not just have it as a separate investment? Because from a tax perspective it's very similar, because also companies don't have interest exemptions, etc. Okay, there also is dividend exemption, but then dividend at 15% still applies. Well, it just depends on what the goal is. Maybe I do want to keep some money for 5 years, and maybe I do want to take advantage of other asset allocation because I can diversify in one investment. So there are other reasons, and you're going to have to look at that. Now, remember I was saying to think about as and when companies or entities own these policies. Now, if a trust had to own an endowment policy, how would that fund be taxed? How do I apply it? Now, interestingly, it goes on in 29 capital A, actually goes on to say, well, if the trust is the owner, you know, and it's not always the trust that's the owner, it's the trustee, but if the trust is the owner and the beneficiaries of funds, i.e., pension funds, provident funds, etc., then it's going to be in the untaxed policyholder fund. If beneficiaries are natural people, then it's in the individual policyholder fund, and if the beneficiaries are neither of the above, i.e. we're going to company policyholder fund. So, look, I don't know how the insurers govern this. I don't know if they ask for trustees, etc., but that's their duty. I'm not going to be too concerned about that. But now, can you see the importance of establishing when a trust does take an endowment in terms of how it's stacked, so that we can decide whether it is actually beneficial or not. Considering that if I have an investment that is not in the Long-Term Insurance Act, held directly by a trust, then remember a trust has a 80% inclusion rate, tax at 41%. So that is quite heavy. So perhaps an endowment is a good thing to go into, because why? Because the taxations in the fund are far kinder. Because the trust also doesn't have interest exemption. It has a dividend, because that is a withholding tax of 15%, but it doesn't have interest, doesn't have rebates, etc. So you have to look at that. There are some questions that have popped up, and we've got 4 minutes for a break. So I think what I'm going to do is just look at the question, make sure we're all comfortable, because I'm going to come back. We're going to look at this endowment thing from a CGT perspective as well, because of second-hand or traded policies. I think it's also important for us to understand the income tax implication there. So let's just quickly look at questions I've seen popping up a couple of times. Oh, it pops up a couple of times, and I have one question. Can I briefly recap approved versus unapproved? Okay, so let's take this opportunity to talk about approved and unapproved. That is important because we're going to be looking at Bella's remuneration. So let me just see if I can open up a clean screen. So what you have is, I'm going to be very, very basic here, but that's the only way I sometimes can explain. You have an employee that joins a company. In this company, the company wants to provide the employee some form of benefits, okay? And it could be for when the employee dies, it could be for when the employee becomes disabled, it can even be for when the employee has heart attack, etc. So dread disease, everything is a D, for heaven's sake. I was trying to separate it. Okay, so the company wants to provide some form of money to the employee or to the employee's dependents in case there is an event, death, disability, or severe illness. So that's one benefit I want to give to the employee. The other benefit that they also want to give to the employee is when that employee retires, I want to make sure that there's certain money for retirement, be it a provident fund or a pension fund, it doesn't matter. Okay, so I want to also have a retirement value to this benefit that I give to my client. We can do this, we can address this in more than one way. So we can decide, well, I'm going to take a scheme that covers only the risk component. Okay, so this is something very separate. It is one scheme on its own. And then I'm going to take another scheme just to cover the pension provident fund. To do this, all I need is to have this section of the fund, the pension provident fund, to be approved with the receiver of revenue. That's what we call an approved scheme. The receiver of revenue has to approve it as long as you abide by certain requirements. And generally, a pension provident fund is always an approved scheme. Very few unapproved pension provident funds, okay? And when this pays out, it's going to get paid out according to lump sum taxation. The fact that this risk is on its own, it is not attached to the fund whatsoever. So it's a very, very separate component, product. All that is individual policies that are smacked under an umbrella, and we make the owner the employer. But all it is, like I was saying, it's individual little life insurance policies that are underwritten. That is not attached to your pension fund at all, so it does not have to be approved at all. SARS does not need to know it, which means then that sits as a unapproved. This now becomes an unapproved scheme. An approved scheme is governed by the Pension Fund Act, and an unapproved scheme is not governed by the Pension Fund Act as a Long-Term Insurance Act. However, what you can do, for whatever reason, maybe from a cost perspective, maybe from a tax perspective, doesn't matter, is you can lump these two together. So you have one scheme, and in the scheme you are covering risk and you're covering pension. But because the risk component is attached to the scheme, the whole scheme becomes approved by SARS. What is the differences here? Let me just clear this because this becomes important to understand. Okay, is if I had risk cover on its own and I have pension on its own, then what happens is this does not have to go to Section 37C. So this is the unapproved part. This is not governed by Section 37C because it's not governed by the Pension Fund Act. This is taxed according to Income Tax Act and not according, well, in terms of income tax, is not taxed according to lump sum, and this is estate dutable. Okay. The pension fund on its own, however, it's a little different in that it is according to Section 37C. This one is not. It is gross income but taxed according to lump sum taxation. Okay, so it's lump sum, and it is not estate dutable. Okay, so there's your rules. But difference is this. When these two are lumped together and both of them come from and both of them are approved, then the risk cover, when it pays out, the risk cover gets attached to the pension fund, and the total amount, the risk amount as well as the pension fund amount, the total amount gets paid out, and it is these rules that apply. Section 37C, lump sum taxation, no estate duty whatsoever. So I hope that has helped a little bit. If it's not, by all means, send me another question and I'll try and clarify. But at the moment, it is a bit of a break, and we'll come back at 11:45. 15-minute break. We need that. Thank you. Chat later. And 15 minutes is gone fast, and we are back. I was just asked to put this up during the break. I'm going to see if I can ask FPI to place this on the website. I'm going to see if they can. Only thing is, when people look at it, they don't know what I'm talking about, so that's why I try sometimes not to have this available, because it will just confuse everybody. But there we are. So let's go back to our notes. We're still on endowment. Oopsie, I think what happened there, oh heavens, sorry. Give me just 1 second. Sorry, I actually thought I was on that page, but I think swapping from one to the other, it just kind of like went straight back there. I don't know why. So let's look for endowments, Pension Fund Act. We're nearly there. Apologies. One more page. Okay, there we are. So we're still with endowments. Now, obviously what I spoke about is where I have an endowment policy in my own capacity, and we spoke about the four-fund approach. Now what we're going to take a look at is, what if the employer implements a endowment policy for its employee? Now, we're sort of really touching on those old deferred endowments, which I'm sure no one is going to do ever again. But it could be that there is an existing deferred endowment, and that obviously has certain implications from a tax perspective, which we need to just quickly cover. And remember, the contributions paid by the employer can be deducted, but as long as a fringe benefit is raised, so nothing different there from a group scheme, etc. The proceeds that are paid are definitely part of employee gross income, but the problem is we are going to struggle to meet the requirements of the exemption under Section 11, because what the exemption says, it says as long as a fringe benefit was raised from the date of commencement of the policy. Now remember, the Act only came into play for the 1st of March 2012. Up until that point, under no circumstances were we obligated to actually raise a fringe benefit. So if this endowment policy was put in place in 1994, then no. Up until 1st of March 2012, there's no ways I would be raising a fringe benefit. Why would I want to do that anyway? Then I might as well not have the scheme. So can you now understand, the Act now goes and says, well, you can exempt the policy from income tax if a fringe benefit was raised from the date of commencement of the policy. So voila. So what do we have? We have this situation. If you still have these policies in place, it's crazy, because the contribution that your employer pays is going to be a fringe benefit tax, so you're being taxed on that contribution. And then when it pays out, you're going to be paying tax, full 41%, not capital gains, etc. Full tax. Now, why would you want that situation? Then, of course, on death, you think this policy will be free of estate duty. No, it will not be free of estate duty. Now I've got estate duty complications as well. Why would I want to have this? Okay, this is a problem. So if I'm looking at deferred endowment setups, the other option is to go preferred endowment setup. So those of you who don't know the preferred endowment structures, please go and find it. I think it's in your financial planning handbook. And if you're really stuck, my email address is Carmen Venter @discoverymail.co.za, and I'll try and help. But first, research for yourself, guys. This is your exam and not mine. From a capital gains tax perspective, we have no problems whatsoever, because it is, well, it won't be risk, but it will definitely be payable to the original beneficial owner, etc. Now, there is a question, but I want to stop here for a sec. Remember that I can have a traded policy or a second-hand policy. So what is a second-hand policy? The second-hand policy is when I take out this endowment policy, it is for my benefit. When it pays out, it pays the original beneficial owner, etc., so I'm comfortable, okay? But someone comes along and says, I'm going to lend you money, or I will give you my house, or whatever the reason is, and you absolutely see this to this person. We used to do this many years ago when someone wanted to surrender their policy because they couldn't afford it any longer, and then another client looked at the underlying investments and would say, oh, I love that policy. And what they would do is they would pay out the surrender value to the original owner, and they would take over the policy. So it is now becoming a second-hand policy. Para 55 does not cover second-hand policies whatsoever. So what is happening is, while this individual had the policy, it would be taxed inside the 5-fund approach. Now it gets given to this individual. There's a potential capital gains tax consequence on this disposal that this person would have to pay clearly. This person now has this policy in their hands, which is happy, and he's going to be paying premiums on this policy as he goes along. All right, but now it's still being taxed in the 5-fund approach. Nothing stops it. But every time this individual makes any form of withdrawals, he can make withdrawals throughout the terms, or when that individual surrenders this policy, I have another CGT event. So you have to question why anyone would want to go into a traded policy or into a second-hand policy, because there's double CGT. CGT in the fund, CGT when it pays out, and of course the premiums that are paying to that policy become base cost. Okay, so question why you'd want to have a second-hand policy. But this said, a lot of things we do. So look again at this business entity and these policies. How often don't we recommend to a client you say to the client, you've got this lovely policy, but what happens is if this policy stays in your estate, we have estate duty problems, especially if there's no life assured. If there's a life assured, nothing is going to save it from estate duty. But this is a life assured policy, endowment policy, and what we say is just give that trust this policy, because then at least it's not in your estate, and I'm going to save some estate duty, and it sits in the trust. Remember, this is a disposal, so I have a CGT consequence there. Then it sits in the trust, and this now becomes a second-hand policy, ladies and gents. So I'm taxing the fund, and when this matures, etc., then there's CGT again for the trust. So just be careful with that perspective. All right. Before I go to a question, let's go to our next one, which is sinking fund. Did I just go back up or did I go down? Sinking fund policies. There's CGT and donations. There was also donations tax for that example that I gave you, okay? So that could be a problem. I'm just talking about that endowment policy. A sinking fund policy, all it is like an endowment policy, it's just that I have no life assured. So obviously I have no estate duty because there is no payable on the death of the deceased. So these type of policies are perfect for companies and even individuals, sole traders, etc., because this is like what we call a sinking fund. It's a pot of money that sits and grows. Contributions are paid in. It's not deductible at all from an income tax perspective. It's all capital. Money sits in this fund, and the employer can go into this, dip into this fund whenever there are things like a restraint of trade, or when there's equipment that has to be replaced, or any form of expenses that is incurred in that business. Then of course there sits those funds that are available. Also tax on the 4-5 fund approach if it's under the Long-Term Insurance Act. However, if you are a sole trader, excuse me, or if you do own one of these sinking fund policies, and clearly when you die, this cash value becomes property in your estate for estate duty calculations. But that is basically how sinking fund policies work. Before I end long-term insurance, I want us to touch on another aspect before we go back to Bella, because in your guideline it talks about the Long-Term Insurance Act and the rules around long-term insurance. So let's look at that, and then before I go to Bella, I will look at that question. So what I've done for you, please understand that I only see the guidelines that you see. I have no privy to the exam whatsoever. So what I do is when I look at the Long-Term Insurance Act, I go into Acts Online, which is so much easier. I try and pull out definitions and sections that I think may be relevant for the exam, because we're looking at long-term insurance as it applies to financial planning. So do I really, from a financial planning perspective, it's very important for me to understand how the long-term insurer, the provider, is actually governed, that they've got to have these audits, etc. No, not necessarily. They've got to do their own compliance. But I'm going to look at certain sections, and these are the things that I sort of looked at. Is of course I want to know what type of product that an insurer can actually sell, okay, what they can't. Then I've picked up limitations on provisions of certain policies, section 54. Obviously, there's regulations which we've got to look at, part 4 of the regulations to the Act, because this does provide quite a bit of limitations to certain products. Remember, endowments, etc., have a 5-year rule, and they also have a 20% premium rule, and there's a little extras under section 54. So I think that is important to look at, because it's definitely a rule around product. Then, of course, section 55 goes on and further to tell me if I do take out cover on life, on whole life policies, what I'm limited to in terms of sum assured depending on the age of the life assured. Then it gives me an age in terms of saying that, well, 18 years and older, so once you become an adult, you can enter into a contract. Then, of course, I've got protection of policies, but that is a general one, but it does apply to products, okay? No, sorry, section 63, my apologies. I was looking at policyholder protection rules. Section 63 is a pretty new, so I think it's 2-3 years old. That is important because it goes and it gives you requirements in terms of when policies will be protected. It's got to be in place for 3 years. If it's not in place and you've used the process to buy other assets, as long as it's within a 5-year period, I can also take a look. Those assets are also protected. Talks about it will not form part of the insolvency estate on death. It's got to devolve upon the spouse, dependents and parents. And then again, also you've got to be able to prove that that was not put in to protect yourself against creditors. So that is a pretty new one that's come in as well. Then of course there's others that I think they may be relevant. Policyholder protection rules, failure to pay premiums. They're not product specific. They are all products under the Long-Term Insurance Act, but that is generally what I've pulled out in terms of the Long-Term Insurance Act and the relevancy into financial planning. Okay, so I'm going to take 1 minute just to quickly look at this question, and we're going to go back to Bella to see if we've covered all aspects of that case study. Hopefully you have been able to sort of tie some of these things together. And then we are going to go to your page 20 to page 24. So if you want to pull that out in the meantime, and we're also going to be looking at your case study. So let me just quickly look at this question. Okay, so here was the question, interestingly, is Section 63 of the Long-Term Insurance Act says, my question refers to Insolvency Act and policies under the Long-Term Insurance Act. Which takes preference, Section 63 or the Insolvency Act? That is why Section 63 was actually, it's always been there, but it has been enhanced, because I think if you recall many years ago it was only protected up to 50,000, now it protects the whole thing. So Section 63 actually says that where the estate is insolvent, be while they're still alive or not alive, it is protected as long as it's a policy under the Long-Term Insurance Act, and as long as I can prove it was not to defraud creditors. So Shatil, my understanding is that Section 63 takes preference to the Insolvency Act. Okay, as long as those requirements are met, and as long as I can prove that I did not do it from a protection of creditor. So I think I'm very confident in my answer to you. And I promise you, I will double check that I'm not lying, and if it's any different, I will ask FPI to put it on their website, because I think it's important. But there is 2 case laws as well. I can't think of it off by heart. One of it was while the individual was alive, the creditors could not attach, and the other one was when the individual had died, so it was a insolvent deceased estate, and the creditors could not attach. So we do have case law to support us there. So I'll leave it like that. Shatil, hoping that that is the correct answer, but I do think it is. I will double check. I've got another question. Would this not also apply to preferred compensation? Basil, I'm taking into account the whole taxation perspective in terms of a deferred endowment. Now let's just quickly take a look at this. You must remember deferred endowment, the way it's structured is, yeah, I've got my employee that earns a salary, whatever that salary is, and here's the endowment, and here's the employer. Now, the employer does not contribute in terms of a salary to the employee. The employer puts it directly into a policy. As a result of this, a fringe benefit has to be raised. When this policy pays out, remember, it becomes taxable, because the Act says that if a fringe benefit was not raised, then this policy becomes fully taxable. Now this is a deferred. If I go preferred, it works very differently, because what happens is there is an agreement that gets put into place between these two, but the employer increases the salary. Okay, and obviously it takes into account tax as well. So the employer is not contributing directly. The employer increases the salary. It is after tax money, so SARS has already got their tax. And then the agreement is that the employer takes that after salary and puts it into a an endowment policy. When that endowment policy pays out, it pays out to the individual, and SARS is happy because there's no a scheme or no benefit, no incentive given directly by an employer. So although effectively it comes down to the same thing, it is structured differently, where I am increasing your salary, and then after tax from your salary, then you are putting money away into an endowment. That's why the taxation is a little different. So I hope I've assisted you from that perspective. Okay, so let's just quickly go back to our case here to make sure that we've covered all these components. We have looked at, let's just clear this to make sure we're comfortable here. We've looked at, of course, the scheme and policy, but again, you now know the requirements for scheme and policy, how it should be structured. You also know how it should be structured from a state duty point of view, so you can clearly see that, yeah, we could potentially have a problem, and it could be seen as if the employer is paying out a policy to benefit Bella. It could be seen that way, so I could have a fringe benefit tax consequence here, and this is not what you want. Okay, so this is something that would require to be restructured in this particular situation. We've also looked at the fact that it doesn't matter that Bella has a buy and sell situation with her sister, because there are various reasons why we would go into a buy and sell, and we must just understand that the chances are that it clearly would not be estate duty free. There's a slight problem here in terms of the valuation, because if you looked at the requirements that we touched on from an estate duty point of view, it said that the intention must be to purchase the shares. So if Bella's shares are only worth 4 million, why is the policy 10 million rands worth? So you may have difficulty in explaining this to the Commission. If you can explain to the Commission and the Commission is satisfied, then there is no problem. But if you are struggling to explain this to the Commission and the Commission is not happy, then what is going to happen is this. There is going to be a state duty implication. And who pays the state duty? It is the survivor. So the survivor all of a sudden has to find 20% on the value of 10 million, because remember, depending on how the agreement is written, I will have to pay the value of the highest of shares or policy. So 10 million has to go into the estate. It's not a matter of, okay, fine, take 20% of 10 million. So I've got to find 20% somewhere. And then, of course, I could have a CGT implication. Why? Because I'm giving the estate 10 million, which is 6 million too much, and I'm getting 4 million in return. So 6 million could be seen to be a donation. So that in itself becomes a problem. Okay, so consider that. So what we're going to move to is now, this is salary 700,000. What we're going to move to is her pension benefits, her group scheme. We have touched on a little bit, so I'm not going to go much into it, but there's the explanation of the unapproved cover, which we now know attracts income tax, there's no fringe benefit, and attracts state duty. Then look at what I've done. I've got risk as unapproved, and then I've got risk as approved, okay, which I can have, which means that all this cover, this 3 times annual salary with the value of the provident fund in terms of death will pay out as one amount, and then this amount will go according to the lump sum taxation and not income tax, and it is not state dutiable. So I have 2 components, and sometimes it's structured like this from a tax efficiency point of view, which is very tax efficient. So go and work that one out and contact me if you are concerned about anything that you may not be understanding. The employer contribution towards the pension fund is 9, but only 2.5 is going to risk. So the 7% is what you're going to take into account, 7.5%. What is you're going to be taking into account from a pension plan perspective. Don't take the full 9% because you're going to be creating a shortfall if you're doing a retirement plan exercise. And of course, the 9% as the total 9% is going to be a fringe benefit tax in the hands of the employee in any event. But remember, we are going to go into RA deductions in a sec. So that contribution that the employer pays towards the investment component, that is going to be deemed to be the employee's contribution for deduction purposes, and not the amount that goes to risk cover. Okay, that's important. I've just stipulated here for purposes of our exercises that we're going to be looking at is the contributions that are not being taken into account. For deduction purposes, 240, we've got to look at that. Retirement age, 65, so yes, part of risk profiling, she's 53. By the age of 65, she's got to come off the fund and off payroll, so she doesn't have, well, she's got 12 years to go, so maybe that gives us enough time to plan. And with beneficiary nomination, the unapproved cover, she's got husband. Remember, unapproved cover is not payable according to Section 37C of the Pension Fund Act, so it doesn't matter who your beneficiary is, I will pay your beneficiary. And in terms of the approved cover, she has not nominated anyone for that cover. So remember, does it really matter? Well, in a way, yes, because if she doesn't have dependents, then I'm going to look at a nomination. But in this case, we know she's got dependents. She's got Pamela as a dependent, and then the mother can obviously attempt claiming as well. And what we've also said, that this is important, I just want to cover a couple of things because we want to go into our notes. Important is that the company is also paying her medical aid, 2.5 months, that becomes a fringe benefit. Okay, so that is important. What is also important is that Bella is allowed to train in her private capacity, so she earns more money. She does have expenses there, okay, but we've got to take into account when we do retirement planning, especially if we're going to recommend retirement annuities, etc., that we understand certain terminology for us to know what we're going to be recommending for retirement benefits. So what I'd like us to go is from here, is to go to your page 20, so we can cover pre and post. Oh my word, sorry, it should be here. Okay, so we're going to, now that we are in her group covers and pension fund, I want us to just make sure that we understand pre and post products. We always seem to be getting confused over the years between what is a pre-retirement product, what's a post-retirement product, and please, you have to understand that setup. Pre-retirement is obviously retirement annuities, pensions, providence, preservation funds. And of course, you've got many other things. You've got tax-free savings, you've got REITs, you've got endowment policies, you've got a whole lot. You even have a savings account if you want. Where post is now actual annuity. So I can go linked annuity, conventional annuity. So it's products that generate some form of income. Okay, so that is very important. I've just looked at a quick question again, and it seems like we still have some confusion between approved and unapproved. So I'm going to ask the delegates that have that confusion to please hold out until the end of the webinar, which I will then try and explain either that or at the end of the webinar, just share with me your email addresses, and then I will email you afterwards exactly how it works. Otherwise, I'll be taking up quite a bit of time on the webinar. Then I've got okay, Garth, I'll address yours, and Samantha, if you can give me your emails. And Guy, you're just querying on the wording of 9% plus 2.5. Okay, Guy's just questioning this bit, and let me just say, maybe it was just my way of explaining it, but I wouldn't be too stressed at my wording. I think it's more important on how the exam is worded. But you'll notice what I've done here is I've said, yeah, employee contributes 9%. Oh, sorry, Guy is actually quite right. Employee contributes 9% of the salary towards the pension and an additional 2.5. Thank you, Guy. I didn't even notice my own case study. So 9% goes to the provident fund and 2.5 only to the risk only. Thanks for pointing that out, Guy. I didn't notice that. Okay, so let's go back to our notes, and we're just going to look at retirement, pension fund, etc. We don't have to touch on it too much because we have sort of spoken it, but notice this, those who are unsure about approved, unapproved, the fact that I've got a retirement, pension fund, provident, this is all going to be approved. It has to be approved by the receiver of revenue. So this is all approved. It is governed by the Pension Fund Act. I've got 37C, 37D that kicks in terms of death. And remember, important, a retirement annuity, pension fund, pension preservation fund has the obligation of annuitizing. So 2/3 has to go into some form of annuity. 1/3 can be taken cash. I can clearly put everything into an annuity if you want, but I can take 1/3 cash. The provident fund bit, you can still take the whole lot because all those changes have been deferred to 1st of March 2018, with the exception of obviously the fringe benefit. Fringe benefit, where an employer contributes to a provident fund, is still a fringe benefit, even if it's a provident fund. So that has not been deferred, okay? In terms of taxed aspects, remember, it is taxed according to the five-fund approach, but it is taxed in the untaxed policyholder fund. So every growth in the fund is free of tax, interest, dividends, capital gains, etc. There is none of that whatsoever. When the policy pays out, it goes taxed according to the lump sum taxation. Note, I take the current value, the pension fund value, provident fund, I add to that any risk element, and together it pays out according to the lump sum taxation, and I am restricted or obligated, the trustees, under Section 37C in terms of the distribution. Okay, important. The amount of money that I don't draw out as cash, i.e. my 2/3, that goes in to produce an annuity, and an annuity is taxed as income tax in full. We spoke about the employer contributions. It's now deductible in full. I'm not limited to the 20% anymore. And anything that comes from a fund. So if I die while I'm in the fund, the money that pays out is free of estate duty. If I die after I've retired, the amount in the annuity is free of estate duty. So we have touched quite a bit on that as well. So that is just a refresher. Now if we go a little further, you'll notice that I'm going to be talking about the deductibility of the contributions by the taxpayer. So this is me and you individually. We are in a fund. Our employer is contributing to that fund. Maybe I'm also contributing to the fund, or maybe not. And maybe I have an individual retirement annuity, and maybe not. And we have this beautiful 11K where everybody is getting quite confused about it, okay? But it's actually simple in a way. So the first thing you're going to do is you're going to look at what is greater. Is the amount in remuneration greater, or is the amount in taxable income greater? Which of these two amounts are greater? You take the amount that's greater, whichever it is, and you take 27.5% of that amount. 27.5% of that amount that is greater, but of course it is limited to 350,000, limited to 350. My colors don't want to play along with me. Limited to 350, and that's as simple as it actually is. I think the confusion comes in terms of what is remuneration, what is taxable income, and just recently, I think recently they've clarified taxable capital gain, because in one instance I included, in the other instance I excluded. So I don't think SARS clarified whether CGT is included or not, because I think they've just confused everything. Okay, so now what I'm going to do is I'm going to take you to an example. You don't have this with you because I wanted you to concentrate on what I'm saying. You will get it. I want to take us back to Bella. I hope all these figures are correct. And just kind of go, what does this all mean? So remember, the first thing I want to know is, what is the total contributions that were actually made? Well, the employer contributed, I hope that is 9%, Guy. Now I don't actually know if it is 9% or not, but bear with me. So the employer has contributed an amount on behalf of Bella. Bella does not contribute because it's not specified, so I'm not going to assume. She then also pays to her own retirement annuity. So in total, she's got 105,000 contribution that can be taken into account for deduction purposes. Now we're going to see, is she allowed to do that? Or can she use the full 105? So some assumptions have been made, so bear with me. So the first thing I need to do is, what is greater? Is remuneration greater or is taxable income? What is in remuneration? I've got her salary and all the fringe benefits that are applicable. So the actual contribution that the employer makes to the fund is fringe benefit. The portion that goes to the risk is fringe benefit, and the medical aid is fringe benefit. So if there was car allowance or anything else, it would be part of remuneration. So she's got a total remuneration of 810,000. Remember, though, case study says she makes other income from other trade. So if I take the other income she makes after expenses, she also has that amount. Now, they don't mention anything about interest or dividends, so I'm going to leave that out. Now, I've made an assumption here that she made a taxable capital gain of 300,000, which I'm going to include in, because I want a total taxable income. Now, this is the important bit. For the purpose of calculating 27.5%, I include a taxable capital gain. So this taxable income for 27.5%, I have to include my taxable capital gain. So I go, which one is greater? Is remuneration greater or is taxable income greater? Taxable income is greater, so I'm going to take 27.5% of that taxable income that says I can deduct up to 462,000. Clearly, I am limited to 350,000, so I cannot deduct more than 350. But there's an additional limitation there, and that limitation says, okay, this is the greater of the two, but you cannot deduct against, you can only deduct, let me rephrase it, you can only deduct against trade income. And the CGT is not trade income. It is, if it was trade income, then of course it would be income and not capital gains. So whatever my deduction is, it cannot go more than taxable income less capital gain, so it cannot exceed that amount. Which you're kind of going, but why is Carmen giving me this type of figure? It just doesn't make sense. I am limited to 350 anyway, so irrespective of my contribution. So even if my contribution is 1,700,000, I'm still limited to 350. In this example, of course, I am limited to 350 based on my contributions, so I can only deduct 105,000. But it's not this type of individual that this act was actually written for. What it is written for are for your high net worth clients, where income, I was meant to take this off. Okay, so just, this shouldn't be there. Let's just ignore that. Okay. I thought I had removed it. This limitation is more for your high net worth type clients, because your high net worth type clients, what happens there? They actually get more capital gain than they actually get income. Am I right? They live off the selling of shares, which is capital gain. So let's look at this. If I had remuneration of 150,000, I'm just going to assume this also working, and I've got trade expenses, and I've made a taxable capital gain, I have a total taxable income of 760. Which one is bigger, remuneration or total taxable income? Clearly total taxable income, so I'm allowed to take 27.5% of 760, which gives me 209. Now this individual has contributed 400-something thousand. Remember, I'm still going by that. I have to take the lower of 350 or 209, which means that if they've made 400,000, I can deduct 209. But I can only deduct 209 against trade income. What is trade income? Trade income is actually only these two amounts, 150 and 50,000, which means that 760 minus capital gain limit to 200,000. So even though this person has made a contribution of 400,000, and according to 27.5%, he can deduct 209, he is limited to trade amount. So I take out the capital gain when it comes to the actual deduction. Hope that makes a little bit more sense. And I am going to take a second or two to look at this question, so I need to make sure you understand this, because I can tell you this is so new, you are going to be tested on it. Okay, so just as I thought. There are questions. So the first question is, does risk contribution rank for 11K deduction? No, it does not. So risk component is taken out for 11K deduction. But Bruce, there is a cost inclusive, cost exclusive. So that does make a difference there. But I'm going to keep it very simple for this webinar, because I don't think from a examine point of view they're going to go into that type of detail. Okay, so at this stage it does not take risk component into account whatsoever for section 11K. Stick to your pension bits only. Then I've got another question that says, regarding deductibility of contributions, will it be set off against foreign pension income as well? No. Zelda, are you saying that I make contributions in South Africa, and you're using those contributions that I make in South Africa to foreign pension income? Okay, I'm saying no. There is a proposal in terms of foreign pension income that is from the 1st of March 2017, so it means that you're not going to get that in the exam, so leave that one out. But that is really to make sure that I'm only exempting foreign pension income and not contributions payable to local income. Okay, so no, I don't think so, but Zelda, I know that Kirsten is keeping tabs on these questions. She is printing them for me, and I will make sure I come back to you on that, but otherwise, no, do not think so. So just find out what charge on the tax studio. Okay, Samantha, I'm not too sure where you're coming from, because I think I've missed that part as well. And I've got a couple of questions on, obviously, approved lump rule. There's another one. Sorry guys, bear with me, because I need to make sure we understand. I've got another question. When we come to lump sum taxation, can the undeducted RA contributions only be deducted against an RA lump sum? Zelda, I think rephrase your question. Are you asking whether the undeducted RA contributions can only go to that RA, or in the same way could I ask, can undeducted provident fund contributions only be, no. Okay, Zelda, okay, Zelda, for the purpose that I'm doing, at this moment, I'm not looking at lump sums. At this moment, I'm purely saying, if I take all my contributions into account, so contributions to the Provident Fund, contributions to the Pension Fund, contributions to my retirement annuity, if I put all that together, how can I reduce my taxable income? Okay, so for the reduction of taxable income, I'm going to take contributions made to all retirement funds, irrespective of what that retirement fund is. Your question, from the way I'm reading it, is, can I deduct disallowed RA deductions to a pension lump sum? I think it depends, because, and let's just touch on this, because this was a question on the workshop as well. So if I have an RA, okay, and I have a pension, that's actually a P, and I have a provident fund, and let's say each one of these funds have contributions that have been disallowed. Okay. If I am retiring, or if there's a death, clearly if it's a death then I'm going to use everything, but if I'm retiring from all the funds together, Okay, so if I'm retiring from all the funds together, then it makes sense to say that I'm going to take all my contributions made and use that as a deduction. Although, from a provident fund perspective, we've got a slight problem in terms of Section 10C, but that is fine, okay? I can utilize them all together. But if I am retiring from the retirement annuity and I'm leaving my pension and my provident, my pension and my preservation, and clearly I can only use disallowed contributions to that RA, okay? If there's anything that has been not utilized, that gets carried over obviously to the next event, then I can use that against my other lump sums if I'm not using it against any form of annuity. So I'm hoping I'm answering your question, Zelda. I think that's more or less where you are coming from. Let me know if you don't. Okay, if I haven't. Okay, so let's just move on a little bit. I know we have a break just now, but it's going to be a very, very small break because otherwise we're really going to run out of time this time. So now you're going to have to bear with me. Okay, so that is my RA deductions. If you're still confused, I'll be looking at those questions at a little later stage. So once I've sent you this example, then I think maybe it will be a little bit more beneficial for you. The next one we're going to be looking at is lump sum taxation. I'm not going to go into it in depth because I think by now you understand totally that I have a retirement tax table, lump sum table, and what goes into my retirement tax table, my lump sum taxation, is a severance benefits as defined. So if it's a severance benefit and it meets the requirements, it will get taxed according to the retirement tax tables. If it's not a severance benefit as defined, then obviously it's income tax. If I've got, and remember these dates are very important from an aggregation perspective, so you must remember those dates. If I have a withdrawal benefit, then it's withdrawal taxation. And if it is a retirement or death, then I've got retirement taxation in terms of tables. I think what would I like to say here is, let me just, please don't forget hypothetical credits, don't forget to aggregate, and I think that's all that's necessary there. I don't think there's anything else you need to know from a lump sum. I think everybody knows how to do this. If not, you're obviously going to let me know what is important there, okay? What we need to go into next, let's see, I think that's our next point, is Section 10C. I just want to explain this again because not everybody has Section 10C in their minds. This is important, okay? Now, Section 10C comes in mainly once you have retired. If you die, there is no Section 10C, so if it was applicable while you're alive, it ends with your death. And if you've never received an annuity, then of course Section 10C will never apply. Okay, so we're going to look at an example of once you've retired, what actually happens with 10C. So some assumptions have been made here. I haven't taken everything from Bella. Some assumptions have been made. But in this case, I said, let's assume Bella does take the full provident fund. Okay, no, I lie. Remember, the full provident fund can be paid out. I'm not limited to 1/3, 2/3. But you can decide. You can decide I want some of my provident fund cash and the rest put into an annuity, or I can take the whole lot cash. It doesn't actually matter. I can decide how much money I want to take from my provident, and I've chosen to take 500,000 cash. My retirement fund, clearly I am limited to 1/3, and this is my 1/3. So at point of retirement, I want my full 837,000 in terms of cash. Remember, before I take my 837,000 to tax it according to the lump sum taxations, I'm allowed to deduct contributions that have previously been disallowed. Now, I've made an assumption here. I've said I see that Bella does have two amounts, but let's assume that by the time she retires, these two amounts have actually grown to 970,000. So that is previously disallowed contributions that I can take into account against the lump sum amounts that I take out in cash, in which case I've got zero amount that has to be taxed. I have not even touched my tax tables. But can you see that I have a surplus amount of 133,000 because I had more disallowed contributions than I have had taxable a taxable amount. So this 133 now forms part of Section 10C, because if I assume that the 2/3 that I have invested, or any amount that I have invested that provides an annuity, if I assume that I get 200,000 out of it, can you see that I can take this 133,000 and exempt my 200,000, so I will only be taxed on the remainder, 67,000, whatever the case is. Okay, so that is how 10C operates. But because of the fact that the Provident Fund annuitization was not implemented last year as planned, all that has been deferred to March 2018, 10C does not apply to any annuity that comes from a fund. So if these disallowed contributions on 970 did come from a Provident Fund, that's fine. I'm going to include that Provident Fund disallowed contribution to work as a deduction against my lump sums, okay? But the insurer then has to say, this 200,000 came from a Provident Fund, let's say 50,000 from the Provident Fund and 150,000 from pension retirement annuity. Then that 50,000 that comes from the Provident Fund, I cannot utilize the 103,000 against. I can only utilize 133,000 against the 150,000 where the source comes from pension retirement annuity. Okay, so that is the important thing to remember in terms of Section 10C. Now, Section 10C, remember this 133,000 is on a first-come, first-served basis. So if at time of retirement this takes place and just before the annuity kicks in, I die, this 133,000 becomes available for the next set of lump sum that I might get. What is the next set of lump sum that I might get? Remember the fact that I've got an annuity, that annuity can be commuted in total by my beneficiaries, or they can take annuity or a portion of each. So the portion that is commuted becomes a lump sum tax in the hands of the deceased, which means I can then use that 133,000 towards that lump sum to make, to reduce the amount that is taxed. So that is how the amounts sort of work with one another. So I am going to touch on one more before I look at those questions, and I think it's important. Let me just quickly look at to make sure I've covered all that. I've covered my Dependency. Okay. The one that I want to look at, because it is relevant to annuities, is of course, let's go back there, and it's not in your guidelines, but it doesn't mean that you're not going to get it. And I'll tell you why I think you're going to get it, because it's something that seems to confuse people over the years again, is this Reg 28. Remember, Regulation 28 only applies to pre-retirement products. It does not apply to post-retirement products, your annuities, etc. So it's important to know that. And also remember, in terms of government funds, Regulation 28 doesn't apply to government funds either. So why are they going to test it again is because we actually get confused. I don't think it's going to be a very simple question in terms of what is the asset allocation for Reg 28. What I do think they're going to do, I don't know if you're going to get fund fact sheets or not. Elan at the workshop mentioned maybe we'll get, maybe won't get. So I'm not too sure. So I'm just bringing out a fund fact sheet based on Reg 28, because what they could do is give you just this page, okay, where they look at the underlying assets. And they're going to say, this is the underlying assets of this fund. Is it Reg 28 compliant or not? So you're going to have to understand, in these little components, is it compliant or not? Okay. I think compliant or not compliant, the other thing that you're going to have to also just pay attention to, you know, all these small little notes here. I mean, I don't know if this one is very, very important, because that's just a commentary. I think what becomes important is also all these things, important information to consider, the price, etc. Because one thing you want to make sure is that this is actually approved. This is an approved fund by the Financial Services Board. Okay, because if it's not an approved fund, what does it mean to you as the financial planner in recommending it? And also, what does it mean to the client if the client has any form of recourse against you. Okay, so I think that's more or less where they're going to come from a Reg 28 point of view. I know these questions, I'm going to have to hold out in terms of questions. I just want to make sure we cover a little bit more. There are post-retirement, these are post-retirement products, these are your annuities. Remember, you've got various types of annuities. You've got linked annuities, you've got conventional annuities. These are compulsory annuities. I've touched on voluntary just so that we understand it. But what happens, I can summarize this here, page 23, the tax aspects of these funds. Of course, the annuities, the income is taxable income. There is no CGT whatsoever. So even if in rebalancing a client's portfolio, you change from one unit to another, or whatever underlying assets that you have that you are going to be changing, there is no capital gains tax that is applicable, because everything that you draw from that annuity is going to become taxed in terms of income tax. Also remember, when I die, I mentioned earlier, anything that is actually commuted by the beneficiary will be taxed in your hands, or in the hands of the deceased, as a lump sum taxation. That's important. Apologies, I was thinking there for a sec. Okay, then obviously none of those annuities are going to be, or even the funds are going to be estate dutable, and there's no capital gains, as I mentioned. So that is basically what you need to understand in terms of annuities. Remember, there are voluntary annuities. The voluntary annuities is a capital element that is tax-free. I've given you the formula there, but a voluntary annuity is not a compulsory annuity, so I don't have all the Reg 28, well, even an annuity, sorry, a linked annuity, a post-retirement product is not Reg 28 at all. It is under the long-term insurance, so I don't have that sort of limitation. A voluntary annuity also not, but remember, the 2/3 cannot go into a voluntary annuity, it's got to go into a compulsory. But the 1/3 that I take out is now discretionary money. If I need to enhance my pension income, I can do that through a voluntary annuity, because it still provides me an annuity income, but I have a capital component is tax-free. So that is something to always consider as well when it comes to that taxable bit. I've spoken about Pension Fund Act and the fact that all that is actually a component of all the pre-retirement funds products as part of the Pension Fund Act, so I don't have to touch on that again. So if I just go back to the case study, okay, so this is all applicable in terms of what Bella actually has, and now we understand what approved is, unapproved, how it gets taxed, when it pays out in terms of taxation, why I felt that it was important to bring in the medical aid bit, so you can see that that fringe benefit is also included in terms of remuneration. And of course, what I've done is I've also given you trades so that you understand how that trade works in terms of taxable income when I'm looking at a retirement annuity deduction. We're going to go into a portfolio, and now I think I'm going to take this opportunity. It is 12:40. We're going to break at 12:45, so I'm going to take a few minutes to look at the questions, and then I think we're going to have a shorter break. I think we're going to have a 10-minute break, but let's just bear with me and let's see these questions. When we come to lump sum, can undeducted or deducted incidents? Okay, that's Zelda's question that she's going to clarify it for me. Tax, okay, I'm going to please clarify. Okay, that I've touched on. Bruce. Wesley says, is passive income included in that trade amount? Yes, it is, Wesley. In relation to the capital gain, okay, capital gain will never be trade. Capital gain, if I trade, it will be income, and it won't be passive income. So your passive income, you're talking about the interest amount above the exemption that is going to be part of it. Dividend obviously is totally exempt, so it can't be part of it. Any other passive income may be, what other passive income? Byron, okay, so yes, let's go like this. Let's try and break your question into a couple of components. The employer contribution that is made is definitely included in remuneration, okay? Because it's included in remuneration, it also forms part of taxable income. And it says, and you say, as well as using for allowable deduction. Yes, it is, because remember, I have a formula to determine how much of that RA can be deducted. So that is very a separate sort of component. And in that, of course, I'm going to be looking at fringe benefit tax to increase my remuneration. It doesn't necessarily increase my taxable income because it's already inside my remuneration. And my deduction is then just to reduce taxable income. So yes, quite right. I'm taking it into account and I'm allowing it as a deduction. I hope that makes sense. Sounds like you're a little bit concerned about something there. Garth, you just sort of, example, 5 million money market at 8%, therefore 400,000 interest income. I assume that's a no. So that 400,000 Garth that you're talking about, so the question is if I put 5 million in a money market, 8% is interest. You assume that there's not trade income. No, that is passive income. Trade income, when would, okay, so give me an example. I know that we have lots of companies that trade income would be, that's an investment company, okay. When would it not be, from an individual perspective, if this is what I'm trading in, then of course that is trade income. But if this is something that I'm not trading in, then it is interest over the interest exemption that will be included in terms of my deduction. If I dispose of it, I've got capital gain. So Garth, unconfuse me if you feel I'm still not answering you correctly there. I'm trying to see where you all guys are coming from, because there's obviously various components. Obviously you're coming from different professions or areas, so I'm just trying to see if I can actually answer you correctly. Christian says, if I understand correctly, and to answer the lady's question, okay, Christian, so you're obviously talking about Zelda. Disallowed RA, pension fund or provident fund contribution gets carried over to the next year of assessment and will form part of the total contributions for the next year eligible for deduction. Christian, I agree totally with you. There's a totally 100%. I was just looking at Zelda's question a little differently based on a question that was asked of me at the workshop, and that was, the question was going like this. If I have an RA and a pension fund, so think of it like this, I've got a retirement annuity and I have a pension fund, both of them have got disallowed contributions. I decide to retire only from the retirement annuity fund, and let's assume the retirement annuity fund, the 1/3 is $1 million, and I only have disallowed contributions of, let's say, 200,000 for that RA, and I have 500,000 for the pension. Can I now take the 500,000 of the pension fund contributions and apply that with the 200,000, so I can have 700,000 disallowed against my RA, or can I do that? And I'm saying no. The fact that the pension fund is still ongoing, I will only be able to use my 200,000 RA disallowed against the RA and not my other pension fund. Okay, so that is basically what I was looking at. I think that's more or less where Zelda was coming from, but I'm sure Zelda will clarify that. Quibus, when will remuneration ever be higher than taxable income? Well, if all I have is remuneration, then of course I have no taxable income. If I have remuneration and I only have interest component that comes in, okay, because remember, not everybody has trade as well, and sometimes people only have trade, which means they don't have remuneration whatsoever. So in that case, they only have taxable income. But there's many people who only have a salary, i.e. they only have remuneration, and they might have some interest coming in, some dividend coming there, and maybe they've got a small annuity. So taxable income is not always higher than remuneration. Garth tries to clarify, if basically, in short, if I only earned interest income, would I be able to deduct RA contributions against this income? Yes, you would. Of course, only the amount that is not exempt. So only anything above 23,800. Okay. Thank you for clarifying that. Okay, so we're 10 to 1 because we've taken up all the time. Let's take a 10-minute break and start at 1 o'clock. Thank you very much. I need my throat to have a bit of a break. But keep those questions coming rather. Enjoy. Okay, so we are back, and thank you all of you for giving me a break. I've not been able to move with all these questions that are coming through, which is fantastic. I love it, and I love them when they are extremely challenging as well. But I do have, I'm going to, for some of you, I have responded to you, and what I've also asked this person to give me these questions, because there's a lot of questions. And I'm not going to be able to cover it. We've got 1 hour and lots to cover, but there is a concern. I'd like to address it now. It was Robert's concern that was raised. So I want to just clarify how I'm thinking so that we know, that you all know where I'm coming from. But there's something I'm definitely going to do for all those that have raised this, and especially for you, Robert. What I am going to do is I will be going back to the drawing board. I will reread those Act sections. And if I still have that understanding, I will double check it with a couple of people before I answer this to you and say, look, definitely go into the exam thinking like this, because this is very important for us to understand. So most definitely I will confirm my understanding. So this is the way I'm thinking. I have a retirement annuity, I have a pension fund, and I have a provident fund. Okay? I happen to only be retiring from the RA and the provident fund. I know some of you are going to go, how can you do that? But let's just assume you do so that I can demonstrate what I'm seeing in my mind. So these are the only two products that I am retiring from. I am still inside a pension fund. Okay, so I know this is employer fund, but let's just assume this one retires at 60 and this one's at 65, so that's why I'm only retiring from the provident fund and I'm only retiring from the retirement annuity. My pension fund still remains in force. So now my calculation is going to work like this. I'm going to take my 500,000, 1/3 that I'm taking out, and I'm also taking my full provident fund, okay, because that is what's available to me. So I'm taking that and I'm adding it together. So I think it's 1.1 million. Sorry, I'm not very good with calculations just so quickly. So I'm cashing out 1.1 million. So the deduction that I am going to be allowed is definitely, I am going to take this 100,000 that the RA has got that is disallowed, and I'm going to take the provident fund that is disallowed, and I'm going to add it together, and I'm going to say I have 300,000 disallowed contributions, and I'm going to tax this amount. So I'm not saying that my disallowed is product specific. No, it's not. It is all my disallowed is applicable to any retirement fund. But I'm just saying that at that event, I am taking the disallowed contributions of the fund that I'm retiring from. In this case, it's these two funds that I'm retiring from. The question is, the fact that this pension fund is still in play, do I also take that 450 into account against this lump sum, or do I wait until I retire from that pension fund to then utilize that 450? Now let's take all this away. Let's take all this away. If I was retiring from all three funds together, then I'm happy to say that I will be taking the disallowed contributions of all three funds into account to tax my lump sum. But my mind is saying, and this is a thought pattern I've had, well, since this has taken place, that I can only utilize the disallowed contributions of the funds that I am maturing from at that point in time, and that I do not touch the disallowed contributions of the fund that is still very active. So this is where my mind frame is coming. I'm not limiting it to product, I'm limiting it to event. If I, at a later stage, retire from my pension fund, then I'm going to be looking at disallowed contributions at the time, and perhaps anything else that I have not utilized under Section 10C. Then I lump that together. So I'm going per event and not per product. So Robert, I'd like your opinion on what I've just said, because I think that is important for our understanding. And at the same time, I am going to clarify this because this is very important. I know that I've had this debate with one of the universities before and I was proven wrong. So that's why this is a thought pattern, but by all means, if any of you, and Robert, if you still are not happy with my thought pattern, please, 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 you must let me know, but I will definitely clarify it for everybody else. Okay, so because we only have limited time and I have lots to tell you, I'm going to only stick to our notes. I'm not going to keep going back to our case study, but what I'd like you to do when we're finished here is to apply what I've said back to the case study, because that's very important. The example that we did is important. Take a look at knowledge, apply it to case study, do calculations if it's so required, and then obviously a lot of theory that goes into a lot of thought pattern, so that's important. There are certain products that are not under the Long-Term Insurance Act, but they definitely are products that are available for your clients. And what I've done here is I've just kindly listed to you in terms of what type of tax you'll be going to look at. So if you're looking at a collective investment scheme, then I'm looking at dividends, which is dividends withholding tax. I'm looking at interest in terms of that exemption. And of course, every time I have a disposal or a switch, etc., I have a CGT event. If I'm invested directly into a REIT, then remember, through a REIT or through a collective investment scheme, doesn't matter. Remember then that is actually taxed as income. Okay, so we don't have its taxable dividends. So that is taxed as income. If I have shares, exchange traded funds, etc., I have the very similar sort of tax consequences, but don't forget that there's always a Section 9C in terms of these two, not in terms of a REIT. There's Section 9C that says whether you trade or not, anything that you have for longer than 3 years, capital gains tax will apply, so it doesn't become income. So i.e. if I'm trading in this, then of course it becomes income, and if I'm not trading in it, or if I've traded for more than 3 years, it becomes capital gains tax consequences. So please remember that. Now with this, what I want us to go into, which is also important, very important, okay, well, I'm not going to touch into business entities in total with the exception of trust. Why am I going into trust specifically? Because remember, as a result of all these interest-free loans, etc., there's a new Section 7C that is coming into play. Section 7C only comes into play as of 1st of March 2017. The thing is, what we need to know is that it says, for loans that exist before and after this date. So if from the 1st of March 2017, there's a loan that existed, it's interest-free or a low-interest loan, then this will apply to you. So I think most of us were hoping that it will only be loans as So just make sure in your note it says, Bella is not yet divorced, but we're going to assume out of community of property because I don't want to do a whole in community of property calculation. And she does die testate because that's important for our calculation. And I've left for her husband a primary residence, share portfolio, motor vehicle, or cash accounts. So the first thing I'm going to look at is the capital gains tax. And I've assumed certain assumptions, certain gains and losses. The primary residence, after the exclusion, there's a 754,000 gain, but I don't worry about it because it's rollover. Same with the shared portfolio, rollover. Collective investment scheme goes to someone, so that attracts, and the motor vehicle is personal, a personal use asset. Everything else will attract capital gains. So there's my total gain. I have my 300,000 debt exclusion at 40% inclusion at 41% tax. So that is the tax that has to be paid at death. I carry that tax over to my state duty calculation. I've listed all my assets here. Okay. Remember, very important, and we have to consider this. I said this, let's see the note. Remember, if we go back, I wonder if I've got that drawing. Okay, if we go back to this drawing, if she dies at this particular stage, okay, she dies, we're going to look at how much previously disallowed contributions that you have disallowed at that point. So I'm going to go, we've got to look at two components. So let's not confuse anyone here. I'm going to look at two components here because I think I confused the workshop a little bit. There's a lump sum taxation and there's a state duty. What I'm going to do is I'm going to take that amount, I'm going to take that amount, and I'm going to take that amount that has to be taxed. So this is the amount that has to be taxed. Okay. But before I tax that amount, I'm going to take these disallowed contributions and I'm going to obviously apply it to my lump sum taxation. That is definitely going to take place. Okay. But lump sum taxation, we definitely will. But before we use them for deduction purposes, we're going to look at were they disallowed at the date of death? If yes, at those amounts that become state dutiable. So when you are making recommendations, lump sum taxation, section 10C, etc., you must take into account that when we are looking at a state duty, this came in 1st of March 2016, okay, but it does take into contributions made after 1st of March 2015. So it's only from that date onwards that we're going to look at these contributions, all right? But that becomes a dutiable asset. Remember that although this is an asset in the, for state duty purposes, it is not liquidation. So if you are looking at liquidity of an estate and making recommendations, the tax on this, the 20% tax on this amount is going to create huge liquidity problems because this 356 in a way is a fictitious amount. It's not a real amount. It's just an amount that I have to tax. But that is important for you to understand that it's already there. It's legislated. You must know that to bring those amounts in. Then under deemed property, I have my life insurance, my group life, remember, unapproved, is going to my husband, but it's a dutiable amount, a dutiable policy. The life insurance policy that I have is being split. And of course, you can question, should that key man come in, should the buy and sell come in, etc. Those are amounts for us to debate, but that's not what I want to concentrate on. And then I'm allowed certain deductions. I still have my executive fee, my capital gains taxes come in, and I am allowed all my Section 4Q deductions. This is calculation as of today. I'm allowed all those Section 4Q deductions, and I have a $3.5 million abatement, and then anything above that is 20% state duty. But, and these are recommendations only, but I think in the exam what you're going to have is not perhaps a full calculation, but perhaps an understanding of how would you do different based on, or what would it look like based on the recommendations. So if we take the very same example that we've had, one thing that is going to be done away with is this roll over to the spouse. Okay, that's a recommendation. No more roll over to the spouse. But because there's been no roll over to the spouse, they're going to allow a 1 million rand exclusion instead, okay, to take care of everybody, whether you're spouse or not. So no more roll over, but I will have this 1 million exclusion there, and there's going to be my tax. So it's not that much because of the exclusion, but of course, the more assets, the higher that tax is going to be. Now, from an estate duty point of view, I'm going to have no more Section 4Q deductions at all. So although this here stays the same, the deductions become a little different. So my capital gain tax is there, but can you see no more Section 4Q deductions whatsoever. But what they've done is they have increased the 4A abatement. It's going to be on a scaled table, and it goes anything below 15 million there will be no estate duty. And the reason why they've done away with Section 4Q is they're kind of going, well, if you're not spouse as per defined, but if I look at the definition of spouse, it's basically everything. If you're not spouse as defined, then obviously this is a problem for you. And if you don't have a spouse, this is a problem for you because I'm going to tax everything anyway. So 15 million is the threshold at the moment. Anything below, not at the moment. Recommended, no estate duty. If it is anything above 15 million, there will be 20% estate duty. And then once it exceeds 30 million, then anything that exceeds 30 million will have 25%, will be taxed at 25%. However, this 15 million, this abatement that we're talking about here, you're going to see it's recommended that any exemptions or exclusions that have been utilized during your lifetime will reduce this abatement. How that is going to work, and if that is exactly what the intention is, I don't know. So yeah, I'm sure SARS will keep a tab, but that is one of the recommendations. So I think from here, do I have the Davis? Yes, I do. I do, because I thought that would be interesting to go from there straight into here. So estate duty we've spoken about. Okay, so no more Section 4Q to spouse. We're enhancing the abatement to 50 million. That will be 20% and then increase to 25% on anything that exceeds 30,000. There's also a little talk about should we keep life insurance exemptions. Remember, we've got 3 exemptions for life insurance, and there's a question about whether that should stay or not stay. Trust, you've looked at trust. You saw that Section 7C came into play already, but it doesn't look like he's totally happy with it. And although this is already in the Estate Duty Act, they're going to enhance these provisions to identify what deemed control actually is. Which will notice that, yes, we do have a lot of alter ego trusts. And, you know, even as a simple clause as a ability to revoke. So the trustees can decide to distribute to Carmen and Tom and Dick and Harry, but the minute they decide to distribute to Carmen, I have the right to revoke. So there's an element of control there. And that means that those particular assets should be estate dutable under this particular section, but it seems like there might be some confusion, so they're going to enhance those, especially where there's an interest-free loan account or low interest. Wealth taxes, I think there's so many wealth taxes. Anyway, that's something they're looking at. They're looking at all vested trusts as well. They want to look at that, and they also want to look at offshore trusts, etc. And looking at the taxation of the trust. You know, at the moment, the way the tax is done is we're going to try and tax the donor first. If we can't tax the donor, we're going to tax the beneficiary, and the last is we're going to look at the trust. They're wanting to change this, so we're going to tax the trust first. All income that comes into the trust is going to be taxed, and then on distribution we must decide whether we want the beneficiary to be taxed, in which case the trust will be allowed a deduction. If we don't want the beneficiary to be taxed, then the trust will not have deduction as well. And there's still question in terms of whether we're going to have attribution rules or not, considering that we've got Section 7C that's into play already. In terms of CGT, you've seen that already, the Para 67 rollover is going to be done away with. We are increasing that 1 million exemption, but what they're doing is this 1 million exemption, as well as donation that goes to spouse, which we're going to look at, ideally they want to carry over so that it reduces the state duty abatement. So what about this divorce thing? About this donations tax? They want to do away with donations to spouse, that it's free of donations tax, and the only thing they're going to allow is a reasonable amount for maintenance of taxpayer and the family. So the only thing I can give to my spouse is money to maintain the family. And how they're going to be determining that, they're going to be looking at the enduring benefit of this amount, i.e. if I'm able to invest it for a long term, that is a donation, and that's not for the reasonable maintenance of the taxpayer. We're going to have lots of fun with some of these recommendations coming in. And of course, you know, those donations in contemplation of death. At the moment, when I sign that agreement, it's not a donation because it only changes ownership at the date of death, so there's no donation tax that takes place at that point. There is a state duty when you die, but of course they want the tax now and not at a later stage. They will also be looking at the arrangements in terms of bare dominions and usufruct. Doesn't mean that that arrangement is going to be done away with at all, but it does mean that they could be looking at how those arrangements are actually taxed. So that is, in summary, I think important is to go download the whole document and just read. And basically what they've got is there's a little summary of all the changes per topic, so trust summary, CGT summary, but it does give you a little bit more insight into why and what they're thinking about. Then of course they got a whole technical document after that summary, which might not be necessary for you in terms of this exam. I want to push forward, okay, because I think after this we probably then are done and I'll have more time for questions, etc. TVM will come a little later. Don't I have a TVM here? Let's just, or did I do it a little later? I think TVM I did a little later. So let's just quickly go to cash flow. You'll notice that what I've given you in terms of cash flow is actually very, very, just give me 1 second here, because I am sure that before cash flow I did look at a quick TVM. I just want to see where that is. I did upload it. My apologies. Okay, I'm not going to spend too much time looking at it at this stage, because otherwise we're going to just use up unnecessary time. But I'm right after this, I'm going to see where my TVM is, because remember they did ask about TVM in terms of the state duty, and I want to cover that as well. Okay. So in terms of budgeting and cash flow, I have given you a lot. I don't think they will ever go into this form of detail. But really what cash flow and budgeting is all about is, remember, cash flow is looking at a situation today. What does my cash flow coming in and going out looks like, and what is that I have to budget for? So budget is more future sort of expectations, where cash flow is immediate. And the cash flow, where is my money coming from? What is flowing in? What do I have to work with, and what is flowing out in terms of my expenses? So the cash flow that comes in, how do I utilize that in terms of expenses that I have? So do I have sufficient? Don't I have sufficient? And of course, what is going to be happening in the future? What is it that I have to budget for? Is it going to be a car in a year's time? Is it going to be university fees in 3 years' time? In terms of Bella's situation, 3 years' time, she's got a mother to look after for. So I need to understand everything that's in for today or for this month. I need to understand where this money is going to. Then I've got to plan with this flow that I have and these expenses, how much of this can I save, put into retirement funds, put into whatever investments to then obviously meet my budget that's going to be happening in the future. So that is the important thing. So let's just look at just a little example. I'm just going to go and summarize this. So your clients are saying that what they actually receive, the flow that comes in, they feel it's 120,000 a year. But let's question this. Firstly, I've got to understand that these director fees have got to be net of tax. I cannot work on amount pre-tax. Why? Because that is not the amount that comes in. That's not the amount that flows in. The amount that flows in is after tax. So I've got to make sure that that is net of tax. Then I've got amounts that probably would vary quite a bit. So would I want to take that in account? I've got dividends from these shares. I've got dividends that are reinvested, so there's no ways that I can use 275. And I've got interest in savings account. Can I rely on that on a regular basis? I don't think so. Because if, say, for instance, tomorrow I've got to, and you know what it's like with clients, they phone you up and they say, oh, I'm sorry, I can't pay my premium this month because I have to replace my car tires, because we didn't budget for it, did we? No, we didn't. So all of a sudden, there's certain income that I can't rely on. Why? Because I've got to take out some money out of my savings account because I've got to replace my tires. So I don't think that that is something I would work on. So far, I would only work on these two amounts because that's more guaranteed, if I can put it that way. They've also got trust income, but it's at the trustee's discretion. So again, that can dry up at any one stage. The trustees can say, oh, sorry, this month or for the next 6 months, I'm not going to give you income whatsoever. So, okay, so dear client, I know you've got 120, but you know what? I'm only really going to rely on 110 because that I know is definitely going to come in all the time. Then, of course, I need to understand where does it flow to. So they give you all these expenses. My mind automatically, and I think it's something you must do for the exam, is start highlighting some of these expenses that you can debate and some of these expenses that are very expensive. So the bond is probably one of the most cheapest loan that you can find, but I'd like to reduce bond as soon as I can, so that is something that can be questioned. Fuel, not much I can do about that. Water and lights, also I can't do much about that, but something we can look at. Food, again, not sure I can do much about that because I myself have found that if I have to tell people not to buy a particular cheese or not to buy too much lamb or whatever the case is, they'll show you the front door very, very fast. So perhaps that's the last thing I'd look at. Education fees are going to stay there. Car repayments could be a potential to look at. Again, life insurance, questionable, but something to look at. Retirement contributions, again, could increase, but I can't increase any of this unless I make income available. My cell phones could be questioned, my clothing, my entertainment, my kids' activities, I can sort of look at that. Can never tell someone to get rid of DSTV, that can become a problem. Gifts, entertainment, a lot of sports and entertainment. I'm sure some of that can be given up if I've got a problem. Medical aid's a problem. Medical expenses could be a problem. Internet, again, this donation to animal welfare just depends on how connected they are, so maybe I can't do away with that. And salaries, etc. So what I'm doing is, as I'm going along, I'm going, what of these expenses can I debate with the client if we have a problem in terms of cash flow and if we have a problem in terms of meeting some of their objectives, okay? If you are just looking at 1 month's worth of monthly expenses, in this case, I have 23,000 surplus according to the client, or if I leave the trustees distribution out of play, I've got 13,000 that I can play with. They do mention that as soon as there's a surplus, they go do something, Okay, they're going to do something with that money, so maybe there's nothing left. But you're going to change their mind because you've got to manage their finances. So 13,000 looks good. Okay, so you like quite happy. You can now say, fine, we're going to put something to an RA, we're going to put something to savings for school fees, for education, etc., etc. But the problem is this: is that very reliable? And I don't always know if it's reliable, because if we ask them to perhaps give us what has happened in the last couple of months, all right? And that's why I always ask what, your clients don't always do this, unfortunately. So this is a process. That's why I'm saying this is a little bit too detailed for your exam. But I want you to get a gist of what we're saying when we're talking about cash flow and budget. Because yes, in that 1 month, the client had a lot of surplus income. And maybe in the second month, they had a lot of surplus income. But what has actually happened over the last couple of months? So this is the income. You see, the income has varied. So there are times that they haven't had passive income. There are times that they haven't had trustees' discretion. So this is varied. So what is it that you're going to stick to? This is what they have budgeted, because they've given you a list of expenses. But this is what they've actually spent, which means that more often than not, they are actually in trouble. Over the last 7 months, they've actually only had 1 month of surplus. Otherwise, they're always running into trouble. So if they keep running into trouble like this, can you see that whatever recommendation you make going into life insurance policies, RAs, or whatever the case is not going to work with these clients. Okay, so you're going to have to really look at everything. And look at the assets, look at liabilities. They give you the assets and liabilities. These are the liabilities they have. But then you've got to go a little bit deeper, and you've got to go, wait, I've got all these assets, but what is actually liquid? These guys are in big trouble, because this is the only liquidity that they have. But this is their expense. This is their liabilities. If this gets called in, luckily they don't have credit cards, etc. If this is called in, they're in big trouble. So what are they going to have to look at? They're going to have to look at selling off some of their other assets, some of their investment assets. In doing that, you understand clearly that there's also other tax implications. There's capital gains tax, there's many other implications. And of course, there are assets that the chances are they are not going to want to dispose of, but they may not have a choice. So this is cash flow, budget, and a cash flow budget exercise that you're going to have to manage with a client. Okay, so that's what's going to be expected of you. They're going to give you sufficient information for you to be able to actually work out some form of solutions. But they have said there budgeting, cash flow, they've said financial management. I don't know how much they'll go into corporate bits, but what I've done is I've given you a little bit of corporate to also take a look at. Financial statements, all you need to do is go and understand financial statements, do a budget. Sorry, I'm trying to get to here. And this is things that you're just going to have to understand. Why do I have so much retained earnings? Why not pay them out in terms of dividends? Maybe that's something you're going to have to understand. Why do I have so much accounts receivable, but then on the other hand, I've got so much accounts payable? So all these things, why do I have so much stock on hand? That's a problem. Why is it moving? Am I ordering too much? Is it moving too slow? Where am I going wrong? So you're needing to understand how to read financial statements together with, sorry, it's very sensitive. I've got a touch screen, so it becomes very sensitive. And I'm also going to have to understand the income. For instance, do I just take that profit into account to determine whether they are solvent or not, and what am I actually going to do with the bit of money? No, I've got to try and work out. Don't forget I've got tax that has to come off first. Don't forget that perhaps this depreciation, this is an accounting entry. This is not what really happens. So that 2.3 can be added to profit for the year. Why is the rental income so high? Why is my cost of sales so high? So can you see that there's a lot of, they've got here operating expenses, and then they also have stationary expense. Wow, what is the difference? So these are the type of things that you would be looking at to help a company to actually do a cash flow themselves. Okay, so that was very fast, but because I know this thing ends at 2. This is how the webinar works. It stops recording at 2 o'clock and just switches you all off, and I don't even have time to say goodbye to you. So we've got 10 minutes, and I can't find my TVM. And is the endowment property or deemed property? Endowment is property because the cash value I own it just before I die. So property, to sort of just quickly give you an idea of how I see it, property is everything I own before I die, and deemed property is everything that becomes mine as a result of death. So life insurance only is payable after death, so that becomes deemed property. My endowment, I'm the owner, there's a cash value, and therefore it is property for estate duty purposes. I don't know if it's too much of a problem from your exam perspective, as long as at the end of the day you've worked out the correct estate duty that has to be paid. If the dutiable estate is 35 million, I think you want to do, Wesley, will it be 30 million at 20 and 5 at 25%? Okay, so Wesley, so far the way the memorandum or the recommendations, it's on a scaled setup. So the understanding is that up until 30 million it is 20%. So 15 to 30 million at 20%. Anything above 30 million, 25%. Marcella asks, can I recap on that retirement contribution that be included in property, please? Okay, Marcelo, let's just see the other questions. Marcelo, I'm definitely going to do that. Okay, so just bear with me. Glover says, referring to my explanation regarding previously disallowed contribution, my understanding is that they group all previously disallowed contributions, which will differ yearly and tax accordingly. They will tax per event, but all the previously disallowed contributions are grouped, not per fund. Okay, I think I've answered that, Quibus. I'm not looking at per fund at all. I'm not looking at per fund at all. I was looking at per event, and I was not going to take anything that is still active. Okay, but as I mentioned, I will definitely clarify that. Wesley, C, I think I'm going to have to address that for you. Sure, there's a lot of questions. Okay, I had Marcelo. Can I recap that retirement contributions? Okay, so Marcelo, this is what I'm going to do, and I'm going to ask, well, I'll email to you directly. So if anyone else wants a recap on the retirement contribution that will be included into estate duty, please will you respond by texting your email address so that when Kirsten gives this to me, I can send it through to all of you. Jason, TVM is right at the end, last page. Okay, Jason, thanks for letting me know that. I will look at that quickly. Anuri wants to know, how would I know what recommendations are effective from the commission report? Should I use it? Okay, so watch here. The Davis report is still a recommendation. If you're wanting to know what is implemented, it is in the bill, in the latest taxation amendment bills that have gone through. And the only one that has been applicable this year is Section 7C. In terms of contributions, retirement contributions, state dutable was already effective last year. Everything else is recommendation. So look at how the question in the exam is being asked. A lot of it will be theory-based. They may just say, if the recommendation does come in, how will it work? Then, of course, you must understand what the recommendation is. But it's not, it's something you need to take into account. So if a client says to you, I want to set up a trust now because I want to do ABC, then you must know what the recommendation from the Davis is, because you've got to warn your client, if you're wanting to save the state duty, etc., that might not be such a clever idea. Okay, so I hope that that has sort of helped out. Megan, will you be making the solutions to the case study available? Yes, all these examples will be available on the FPR website. So Jason says the TVM is right at the end. I've got 6 minutes to go. So let's go right at the end of the notes. Right at the end of the notes. And Jason, so let's go there. Yeah, I think Jason is, oh, there we are. Thank you so much. I think Jason, it's at the end of your notes, but not at the end of mine. I apologize. I think what you need to do is this. I know I'm talking about a state plan, okay? But remember, all the needs that Bella has two sort of goals, if I can call it that. One is while I'm alive, and one is when I die. Now you'll notice that 2 needs came up immediately right at the beginning, and one of it was her mother needs, let's just look at her mother. Her mother needs a certain amount in 3 years' time if I'm alive, and of course her mother is still going to have that very same need if I die. So your TVM is going to be slightly different. In terms of if I'm still alive, I've got to take a look at, and here's the whole TVM I've given you the whole lot, okay, is how much income am I going to need today? How much capital should be made available today from an investment point of view to address not only the 5,000 Rand a month I'm going to be needing in 3 years' time for a period of 10 years. So I need to know what that present value of those payment is, okay? And at the same time, of course, where's my 1 million? Okay, I don't know where I put my 1 million. This is just the income that's needed. Okay, so I'm going to double check what I'm sending through to you. So I need R1 million in 3 years' time, and I need 5,000 for 10 years. So I've got to calculate the present value of the income need as well as my capital, and I've got to work out how much capital do I need, or if I want an escalating annuity. So that is the TVM that I've given you. But the TVM will work very differently if I need to say, well, what if I had to die today? Of course, if I have to die today, then immediately I have to make that capital available. So I'm not going to future value my apartment that I need my R1 million, and I'm not going to future value my payment either, because it's something that has to be put in my life insurance today. So that's the type of TVM they're going to be looking at. From an estate plan point of view, if I die today, what capital do I have to have available now? Do I have that liquidity in my estate to meet those needs? Or how much life insurance am I going to need to make sure that when I die, I pay out that amount to my beneficiaries immediately to cater for their actual needs? Sure, ladies and gents, I think in the last hour we really pushed. I can even feel that in my throat, that I'm like, it's dying on me now. We've got 3 minutes before this whole thing sort of just closes on us. And I would like, before I do that, I know there are questions. If I don't manage to address it, It will be addressed. Here's my email address, Carmen Venter, no full stop, Carmen Venter @discoverymail.co.za. Please, if I have not addressed anything or if you're still concerned about anything I've said, I want you to email me so I can respond. Very, very important. But I'd like to say all the best for those exams. Use the knowledge that you have, apply it to your case study, answer the questions, ladies and gents, answer the questions. The first example was very important where it said no calculations, so if you had spent 3 pages in calculations, you would not have got the marks. So be very, very careful. And I know you can do it. So all the best, and I'd like to hear from you guys and ladies in terms of how it went, and especially when you pass. Of course, if you haven't passed, you're allowed to tell me as well, but I'm hoping that everything is just a pass. So I'll say goodbye to those for you that want to say goodbye to me now, and I won't have much time before this thing shuts down on me. Just know that we are going to come back to you in terms of those questions. Ladies and gents, I hope this was a valuable 5 hours or 4 hours, and all the best. Have lots and lots of fun. Have a great afternoon. Goodbye.